Okay, so let's start. Good afternoon, everyone. Welcome to this first session of our Module 4 on the law and economics of vertical restraints. This session will be presented by our two speakers that are part of our faculty for 10 years and more, if I'm not mistaken. So it's an honor to have you both still in our program, really. Luc Peperkorn is the principal advisor on antitrust policy in DG competition in the European Commission. He also co-authored the guidance on the Commission's enforcement priorities in applying Article 102. He regularly speaks at conferences and has published widely on EU competition policies. Frank Wakeman is the founding partner of Contrast, a top-ranked independent law firm providing specialized competition and EU law advices. He advises clients in EU and competition law and Belgian business law. He is a regular speaker at conferences and universities such as Antwerp universities and Liège of K11. I'm missing one of the two, or not. Please do not hesitate to open your microphone if you have a question. We will do breaks, so you have the time to think about question as well. Open your video, please, now so we can see you. And dear professor, the floor is yours. So please enjoy this session. Thank you.
Okay, thank you, Valerie. I don't know, Luc, you want to make...
Thank you.
Well, welcome on board in the vertical module. We have 3 wonderful sessions ahead of us, and our job is to make sure that by the end of the 3rd session, you have the vertical regime at your fingertips and you understand how to work with it in practice. Let me see where we can get the slides moving. Voila. This is the menu for today. We are going to give you the legal and economic framework in general terms, and we're going to focus in particular on the scope of application of the vertical block exemption regulation. And the vertical block exemption regulation, Regulation 330, is a bit the beating heart of our 3 module sessions. It's the block exemption that deals with vertical agreements, and we'll see in a minute how wide its scope is, what the conditions for application are. It's that regulation which is in the forefront. And typically, Luc, we invite you, if possible, to have the text of the regulation and the vertical guidelines at hand, because once we start diving deeper, and that probably will be a bit more in the next 2 sessions, deeper into the matter, it would be really helpful that you can check the regulation and see really how it functions.
Yes, so make a printout of the regulation at least and have it at hand. Secondly, if you have questions or if something is not clear, we prefer you not to use the chat. Just simply open your microphone and intervene, comment or ask, so that it becomes lively. And always think, if you don't understand it, someone else will also not, so you better be the first to ask it. And finally, indeed, thank you for all opening up your cameras, because that makes it much nicer for us to see who we are talking to. Thanks.
Quick question for practicality purposes. Is the sound okay for you? Or do we need to grab the microphone closer? No, the sound is okay? Perfect. That is important. You'll see on this slide that at a given point in time, we're going to put you to work. That's the sort of nasty people Luc and I are. In a sort of workshop environment, we're going to shoot a couple of real-life situations at you and see what you believe is the appropriate response to that real-life situation. And then we will, at the end, wrap up to make sure that the building blocks of today's session are well in our minds and we can move on to the next stage in our following session. Let's see whether we, voila. We're going to the legal framework. And again, this time you may simply nod, or if indeed something is unclear, wave right away. Luc and I assume that in previous sessions, you have been looking at the basic parameters of Article 101, 102. that you understand the mechanism of 1011 and 1013, and that you know that 1013 either can be secured on an individual basis through a self-assessment, and that you have to meet the 4 conditions of 1013 for that purpose, or that you can secure an exemption through a block exemption. And we assume that you know the general mechanics of what a block exemption represents and how it works. Another point we hope you have seen, and that's a beauty for me as a practitioner, that you have seen the concept of conversions. It's a concept which is embedded in Regulation 1/2003, and which in very practical terms really means that from the moment that there is an effect on trade between member states, it does not really matter what your national competition law says on agreements that are covered by Article 101. The Article 101 solution, including the 101(3) solution, will dictate the outcome. In practical terms, and again, I will be very brief on that because we assume you've seen that in previous session. Just imagine that your agreement in Poland is covered by the block exemption. Well, then the Polish Competition Authority may say what it wants. In that case, Polish competition law cannot be applied to say that that agreement is invalid on account of Polish competition law. That's in a nutshell conversions. It's much more complicated than that. But again, unless somebody waives, we assume that's something which has been discussed at sufficient length in previous sessions.
You'll see that the roles that Frank and I do is a bit that Frank explains the regulation itself and the mechanics, the kind of tick the box approach that he also has put on the slide. I will try to, where possible, also explain why the rules are the way they are. So what motivates the rules? And that is because I think it is good to realize that a block exemption regulation, of course, is a legal instrument. And it is meant to be clear and that you should be able to tick the box to find out whether you are covered or not covered. But at the same time, competition policy is an economic policy. So it is not a form-based tick the box approach simply to apply some legal concepts. The thinking behind the block exemption regulation is also economic. That is logically because the competition policy is about market power and about the control of market power. And that means it is about effects. And you could argue those two things contradict each other a bit, because if something is about effects, it becomes less clear, and then it is less easy to put a tick the box, a form-based approach. But nonetheless, and that's also what I'll try to explain in the different sessions, is that the choices made for how to structure the block exemption is not just because of legal certainty or legal principles, but is as often or even more inspired by trying to translate economic concepts into a practical application. So the level of a market share threshold will be determined in part by economic concepts. The use of a market share threshold may be inspired by economic concepts. The fact that block exemptions differ depending on the type of agreement, different between, for example, horizontal agreements and vertical agreements, or different between vertical agreements and licensing agreements, already indicates that it is not just a legal question and it's not just legal issues, it is the economic issues that motivate how and why the rules are the way they are.
The kind of legal instruments you would want to have in your wallet when dealing with vertical agreements, and we will dwell in a couple of minutes on the concept of vertical agreements. What are we talking about? The materials you would want to have in your wallet are the following. Certainly Regulation 330, and that is the block exemption regulation. From the moment an agreement is restricted of competition, you would want maybe to apply the regulation, the block exemption regulation. The regulation is accompanied by vertical guidelines. I don't know whether you have seen the horizontal module already. There you have horizontal guidelines. Also in the vertical sphere, you have vertical guidelines. And they basically do two things, broadly speaking. On the one hand, they give certain explanations by the application of the block exemption, but almost 2/3 provide guidance in case you need to conduct a self-assessment under 113. For one specific sector, you have a specific block exemption that is for the motor vehicle sector. Anything to do with passenger cars, buses, trucks is governed by regulation 461. We will not discuss it in detail. If there are people involved in the car business, and maybe just 2 words very quickly. Regulation 461 makes a distinction between the distribution side of vehicles and the aftermarket side. For the distribution side, it simply cross-refers at the moment to regulation 330. So on the distribution side, in the car business at the moment, the same principles are being applied as in all other sectors from a block exemption perspective. The second part, the after-sales market, is translated into 3, and we will not discuss those in detail unless you're interested, 3 specific additional blacklisted provisions that govern the aftermarket business. So specific, sector-specific regulation for the motor vehicle business, again, accompanied by supplementary guidelines that will give you certain explanations on things like warranties, how to deal with the appointment of independent workshops, blah, 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 blah. Guidelines specifically tailored towards the motor vehicle business. Important, as you will see in a couple of minutes, the de minimis notice. The effect on trade notice is important because it helps to distinguish between purely national situations where European competition law does not enter into the picture, or situations where indeed, on account of the sufficiency of the effects, competition law, EU competition law applies in addition and must be applied in addition to national competition law. The next on the list is a subcontracting notice. That's an old animal going back to 1978. Probably one of the oldest notices still in the books, I think, which is alive and kicking, which basically deals with me as a producer asking you to produce something for me, which I then typically will start using in the production of some other product. I ask you to make a steering wheel of the car that I'm going to produce. You are my subcontractor. The subcontracting notice deals with under which conditions are certain restrictions which at first sight seem to be covered by Article 1011. At first sight, they would be covered. Can they be held outside Article 1011 given the specificity of that relationship? And then you have the horizontal guidelines which deal, and you have the indication there, paragraphs 225 and following, with commercialization agreements in case competitors, actual potential, enter into commercialization agreements. I, as your competitor, attribute certain distribution rights to you for my products. Well, that is something which typically will not be governed by our normal vertical block exemption regulation. It will be governed by the horizontal guidelines that offer specific guidance. You see guidelines, you don't see block exemption, which means in fact that these guidelines will help you to make a self-assessment, an individual application of 1013 to that relationship. That was maybe a lot, but if you want indeed a collection of the legal materials that will help you in the distribution sphere, that is your set to work with.
Some background, let's say, to the history of block assumption regulations. In the 90s and 80s, there were block assumption regulations which were often more sector-based, or so there were specific rules for not only cars, beer and petrol. And there was, of course, a big lobby to keep that, in particular because those rules were normally more lenient than the more general rules. When I got involved in making the block assumption regulations at the end of the 90s, we decided to make the precursor of the current regulation and to go for a system of one regulation for all vertical agreements. I remember that there was a push from the different sectors, like the beer sector and the petrol sector and the car sector, who wanted to keep their old regulation, their special position. The only one who was able to keep it through their lobbying was the car sector, but we already warned them, guys, this is not clever, because by the time that your regulation will run out, what we can do is only 2 things. We can either make you fall under the general regulation, or we can make stricter rules for you. But we will not be able to make more lenient rules. And the car sector didn't really believe this. But in the end, what you see on the current slide, the regulation 461 for the motor vehicles does exactly that. It applies the general rules for most part of distribution. And for the aftermarket, there are special rules, but that is because they are more strict than the general rules on vertical under the vertical block assumption regulation. So the rules currently are, it's either the general block assumption regulation or there's something specific which is more strict because there are specific needs in that sector, in this case, the aftermarket of cars, where because of the size of the amount of money involved, there are people not realizing that 2/3 of the total costs of a car are in the aftermarket, are in the repair and the servicing, that there is special needs for access and transparency in those markets.
Unless there are questions on this, it's just a basic outline. So at least you have a shopping list if you want to go shopping for legal materials. From the legal side, this legal framework, we go into the economic framework, and I'll pass the floor right away again to Luc because he's the expert on that aspect of the framework. And what you see on the slide here are the various possible negative effects of vertical restraints. And vertical restraints are restraints built into vertical agreements. For instance, I impose a non-compete obligation on you as my distributor. You should not be dealing any competing products. That is a vertical restraint. Well, there are indeed demonstrable negative economic effects of vertical restraints. And those we see here on the slides.
Yes, and so this goes back to what I said before, that competition policy is in economic policy. And so the question is, how do the rules work and why do we have the rules? And if you think about that, then the first question is, why should competition law be concerned about vertical agreements, which are normally agreements between parties who do not compete? One is a manufacturer of a product, and the other one is a distributor of the product. And the first, the manufacturer sells the products to the distributor for resale. So why would competition law be involved? Why would it be having potential issues with such agreements? Because you could argue there is no competition between the parties. So where comes the problem from? Indeed, if you think about competition law, the first thing that comes to mind is intuitively agreements between competitors. Because everyone understands that if competitors get together, like Adam Smith already said, if competitors get together and they start talking, before you know, they start talking about how to increase prices and reduce output and increase their profits and do harm to their customers. But here, in a vertical agreement, one is the supplier and the other one is a buyer. The customer is in the agreement. So why would there be harm to a customer if the customer itself is in the agreement? And therefore, indeed, it requires a bit of explanation why competition law is also concerned about vertical agreements between non-competitors normally. And that is indeed the potential negative effects are on the slide, and they are in, as Frank said, in the guidelines. And I think they are based on the one hand, experience, on the other hand, economic theory, and also logic, I would say. So what are those negative effects? The first one is that an agreement can be used to foreclose at the level of the suppliers, other suppliers. So the manufacturer can, for example, say to the buyer, I'm willing to supply it to you, but on condition that you don't buy from anyone else, that you don't buy from my competitors. So you foreclose potentially other suppliers upstream from having access to at least this distributor, but potentially also other distributors and potentially the market, depending on how important those distributors are on the market. The same is possible the other way around. I mean, the buyer may say to the manufacturer, the distributor may say to the manufacturer, I'm willing to distribute your product, but on condition that you give me exclusivity for a particular territory. I will be the only one selling your product, or in total, only sell to me and to no one else. And again, you can see how that might lead to a foreclosure of other distributors and might limit competition at the distribution level. A third possible negative effect is softening of competition and facilitation of collusion between suppliers. For that, I first have to make the distinction clear between softening of competition and facilitation of collusion. Softening of competition is when the incentives are changed in such a way that different competitors automatically have less incentive to compete. So they don't need to agree on it. It is simply that because you change the structure in which they operate, that they will have the incentive to compete less. Facilitation of collusion is more where you make the possibilities to collude, to make, for example, a cartel agreement more likely or more possible. This is often captured under the phrase a reduction of inter-brand competition. And you may, for example, think of if not only I say to my distributors, only buy from me, but also my competing suppliers say the same to their distributors. This may make it in total in the market less attractive to compete, because at the distribution level, it is now more difficult for consumers to compare products. And as a result, there is a softening of competition at the distribution level. The same idea, but now about facilitation of collusion could be an example where if I, as a manufacturer, start to use what is called RPM, resale price maintenance, if I tell my distributors at what price to sell, and I punish them if they sell at a lower price, then my rivals can more easily see at the distribution level whether I stick to a potential cartel agreement. So if I, manufacturer, want to collude with Frank, another manufacturer, but our problem is that we don't know of each other whether we really stick to the agreement, the moment that the prices at the retail level stay the same because I apply RPM, then Frank knows if the price changes at the retail level, it's because I have changed it and not because my retailers on their own account have changed it. So it makes it easier for Frank and me to check whether we stick to our cartel agreement. So a vertical agreement can be used to support a horizontal cartel. The same, of course, is also possible at the buyer's level, at the buyer of the product level. If I go back to the example of RPM, it's obvious that if Frank and I are competing distributors and we want to collude on price, it is very helpful for us if we can convince our suppliers to ensure that the price is the same everywhere and that no one of us can deviate from the price. So that we use the upstream manufacturer as the integrator, as the operator of our cartel. And the last one is often called hindering of market integration. And then people say that is something specific for the EU, and therefore it is not really about economics, it's not really about normal competition law, it is a more political aim. But I always say that is not really what is at issue, because the hindering of market integration is really about reducing harm to consumers through price discrimination. And the background is always that it's always about resale restrictions, where a manufacturer says to distributors, you are not allowed to sell into another territory. And this is often because the same manufacturer is selling the product in another territory at a higher price because the competition in that market is less strong. And he's selling at a lower price in a market where competition is more fierce. But then in order to protect the high price in the high price market, he wants to restrict the buyers, the distributors in the low price market to resell into the high price market. And of course, you can see that the consumers and the customers in the higher price market would benefit from the parallel trade. So there is a harm to consumers through resale restrictions, which basically uphold price discrimination. Now, we will go into a number of these type of negative effects and a number of the types of restrictions that can be held responsible for possibly creating such effects later on. But I want to give you already some general rules, which also explain a bit why the block assumption is as it is, which means it is a very general block assumption regulation. The first is that almost every negative effect can be obtained not just by one specific type of restraint, but by many types of restraints. So, as I gave the example, the anti-competitive foreclosure of other suppliers, the manufacturer may say, don't buy any other products, a non-compete. And we also try to use tying. If you buy my product, only then can you also buy another product. You may also want to become the category manager in the distributors in the supermarket and be the one responsible for organizing the products on the shelves. There are various ways through which foreclosure of other suppliers is possible. That also explains why it does not make sense to have different rules for different types of restrictions normally, because the only thing that you create is a push from one restriction to another. Therefore, that's why we have more general rules. The second one is, for every negative effect, you need to have some level of market power. If truly both supplier and buyer are very small on the market, then whatever they do, it will never lead to a negative effect on the market itself, simply because there is too much possibilities for the rivals to still compete. And the only thing that will happen is that they will lose market share because they become less attractive. And finally, I think there's one basic question. So the previous point, the need to have a degree of market power, also explains why there are these kind of instruments with market share thresholds which create safe harbors. So the de minimis, which we will talk about later, and the block assumption, they all work with the idea that below certain levels of market power, problems are less there or are not there, and therefore safe harbors can be made. There's one last question that we have to confront every time that we do a vertical case and for every situation, which is, in principle, you would expect if two parties have an agreement where one side is restricted in its freedom, that side will normally not likely agree to the agreement. And as you see, I mean, the only way for me as a manufacturer to foreclose Frank as a rival manufacturer from having access to my distributors is, for example, to tell them, don't buy from Frank, or I will tie my product to another product which you need, or something else, but which always runs through the fact that I restrict my buyer, I restrict my distributors in their freedom. So you would think they will normally not appreciate this, and therefore they will normally not want to agree to this. That is also why economists have the kind of general rule that you can expect that the other side will give a counterweight, and that therefore vertical restraints will normally not done for the negative reasons, and therefore will more often be done for efficiency reasons, for positive reasons, and therefore should be dealt with less strict than horizontal restraints, than agreements between competitors. However, there are two basic mechanisms which explain why in a vertical relationship, the other side is nonetheless willing to accept restrictions of its freedom, which are not in its direct interest, and which harm competition, and which therefore make its own possibilities less. And the two mechanisms are: one, the other side has no choice, in the sense that, for example, I'm a brewer, my beer is very popular in the market, many people want to drink my beer, you are a pub. And if I say to you, the choice is either you can sell my beer, but then you accept the conditions, like not selling Frank's beer, or I'm not going to supply to you, you may feel that you have very little choice to refuse my conditions. Economists often call this a coordination problem, in the sense that they, of course, realize that if you're all pubs, if you were clever enough and organized enough to get together and say, we as a group, we as all buyers, we're not going to accept your condition to exclude Frank's beer, because we also have some customers who like Frank's beer. It's unlikely, but there are some. Then, of course, if you would organize yourself, you would be more likely to resist my demand for a restriction. But often there is a coordination problem. You're not able to get together. Your group is too big. You have too diverse interests. Maybe competition law may even be looking up at it a bit suspicious if you get together as competitors, as competing pubs to organize something. And therefore, each of you, confronted with a choice that I'm posing to you, it's my beer, but not Frank's beer, or not my beer at all, you may think, I better accept, even though the advantage for me is not directly there, but at least I have the beer that is most popular. The second mechanism is where I make you party to the profits. So where I make you share as the other side, who in principle has limited its freedom, in the extra benefits that I get from foreclosing Frank from the market. So the moment that I foreclose Frank from the market and I reduce competition, there's extra profit on the table. Of course, my first aim would be all for me. But if there is too big a risk that you might refuse my conditions and go for Frank's beer, I might want to make you complicit to the whole operation by sharing the profits with you. The profits of foreclosing Frank and limiting competition. So those are the two basic mechanisms. And if you have a vertical case later on, and if we later on see different situations, that question always pops up. What makes it possible that in the vertical agreement, one side is at face value limited in its possibilities, is accepting something which is not in its interest, and is still accepting it, while it limits competition and is limiting its own possibilities to be active on the market. Okay.
So this was a short introduction to the negative effects, the economics of verticals underpinning verticals. Now we're going to move away a bit from the economic aspect into the legal aspect. And the backbone of our explanations will always be that we will try to put our vertical agreement within the scope of the block exemption. Why is that the case? That is, if we are sure that we're covered, well, in that case, we have a safe harbor. We know that our agreement is not a problem under competition law, it is enforceable, it is valid. And that's therefore the backbone of the discussions we're going to have. And the first question we need to answer that, of course, when can an agreement benefit from that exemption? And a second question, which immediately pops up, just imagine that for one reason or another, and you'll find out in a minute what that could be. But one of the conditions for the benefit of the block exemption is not met. Am I lost or is there a way out? These are the basic legal questions that we need to address. We're going to devote now, probably the next hour or so, to the conditions that govern the scope of application of the block exemption. And you'll say, Frank, how boring can it get? But this is really important. Each of these points, as a good practitioner, you will need to tick and make sure that each of them points in the right direction, i.e. towards the block exemption. Quickly looking at them, first of all, we will need a vertical agreement, and we already discussed that, and the question is, what is that? 2, we will need appreciable restriction of competition, otherwise we don't need a block exemption. We need a 101-1 situation to move into the block exemption sphere. 3, the application of the block exemption is governed by certain market share. People often use the word thresholds. In fact, there are limits, market share limits. We're going to look at those. There's a particularity in the block exemption about the presence of intellectual property rights. Could be trademarks, could be something else, commercial know-how. What is the implication of having IPR in my vertical relationship for the application of the block exemption? The 5th point is, okay, as Luc mentioned, if we have a vertical agreement between non-competing undertakings, that is all perfectly fine and dandy, but there could also be a situation whereby the parties in fact are somewhere competitors. What does that do to the application of the block exemption to my particular relationship? And finally, Luc already mentioned, we have, roughly speaking, 5 block exemptions on the books now. What if my vertical agreement also enters into the field of another block exemption? What does that do to the application of my general vertical block exemption regulation 330? This is our shopping list. These are the 6 points which you as a good practitioner will be ticking off in order to ensure that you can make valid application of the block exemption. The first issue is we need a vertical agreement. And again, a bit boring maybe, but we can really find the definition in the regulation itself, Article 11A, and let's read it together. Vertical agreement means an agreement or concerted practice entered into between 2 or more undertakings, each of which operates for the purposes of the agreement or the concerted practice at a different level of the production or distribution chain and relating to the conditions under which the parties may purchase, sell, or resell certain goods or services. It's a mouthful, and as good lawyers, let's simply tear that definition apart and see what it really entails. The first thing is we need a vertical agreement or a concerted practice, which in fact means that purely unilateral conduct is not covered by the block exemption. We need a 101 setting. And here you have a reference to the Bayer case, the Adalat case, which is a case really at a crossroads between when do we have an agreement and when is something unilateral. And it's worthwhile looking at the quote from the court. It basically says the mere concomitant existence of an agreement, which means in normal terms, the fact that there's also an agreement out there between the parties, which is in itself neutral and a measure restricting competition that has been imposed unilaterally, does not amount to an agreement prohibited by that provision. Does the mere fact that a measure adopted by a manufacturer, which has the object or effect of restricting competition, falls within the context of continuous business relations between the manufacturer and its wholesalers, is not sufficient for a finding that such an agreement exists. Let's go to layman terms. What does this mean? We have somewhere, Luc and I have a business relationship, and we have indeed an agreement. It's still perfectly possible that I would engage in unilateral conduct that is not covered by Article 101. In this particular case, in Adalat, what was the issue? The issue had to do with cross-border sales. And in that context, Bayer had simply decided that it would deliver a particular volume. I take shortcuts on the facts here, a particular volume to its distributor and nothing more, knowing in the back of its mind that this would in practice limit the ability of the distributor to start selling cross-border. The bottom line question is, do we have here a vertical agreement which in a sense restricts that wholesaler in engaging in cross-border trade or not? In Adalat, the court decided that was not the case, because there was in fact no consent on the part of the distributor, there was no cooperation of the distributor. This was simply a unilateral decision taken by Bayer to simply deliver a particular volume and nothing more to the distributor. So here we're talking in the vertical sphere, the block sphere, only about things which are either an agreement or a concerted practice. Important for theory court, and some of you may be competition lawyers, but also civil lawyers, the notion of agreements and concerted practice is extremely broad in competition law. It can mean an explicit agreement. I sign with you a distribution agreement. Could also be an implicit agreement. I don't sign anything with you, but we understand each other and we more or less have an understanding as to how we're going to behave in the market. Could even be an exchange of intentions. We intend to behave like that, but we're not formalizing our relationship. And again, a concerted practice is even a softer form of that, and I assume this has been discussed in a previous session. What is the practical implication of this theoretical approach? The practical implications that you as a practitioner, when you will be analyzing a vertical agreement, that you should not make the mistake of simply looking at a formalized document. Let me give you a practical example. Luc and I, in the meantime, we know more or less the block exemption, and we draft a distribution agreement which is nice and dandy, perfect. The clauses are, tip-top, spick and span. However, in practice, we talk to each other, and I impose vertical prices on Luc when he resells in the market. Nothing which is formalized in the agreement. In fact, the agreement would typically contain your standard clause that I can recommend prices to Luc, but I can certainly not impose prices. But in practice, what we're doing is we know each other. And I impose on Luc prices which he puts in the market, which is this famous RPM problem. Now, in your analysis, it's very basic what I'm telling you, but in your analysis, it would be ludicrous to simply look at a formalized agreement. As a good practitioner, you talk to your client and you basically ask what is happening, particularly in the areas which are sensitive under the block exemption. We're going to look at those later, such as RPM. So keep in mind, the vertical agreement we're talking about here is the whole of the relationship and not just the formalized document that has been signed by the two parties.
I think it's good to realize that, a lot of those cases are, for example, built around the manufacturer requesting something which is not formally in the agreement, like requesting not to lower the price or requesting not to sell outside a particular territory or to sell cross-border. The request may be joined by certain implicit or more explicit threats, like supplies might be less supple and less often. And what you have to look at is not only whether there was such a request which was uttered, but are there other threats linked to it, or, and that is the more kind of tacit acquiescence, is it in fact followed up by those who get the request? So if certain distributors have lowered their price, the manufacturer comes and says, I think it's much better if you increase the price again. And subsequently we can establish that indeed the distributors did increase the price again. On that moment, you can say there is acquiescence, and therefore there is also an agreement. If it was just the uttering of it's not so good that you lower the price, I'm not really happy about it, but the distributor continues with the low price, we cannot establish a concerted practice or agreement because there is no concurrence of wills. The distributor is not following what was being requested. I would advise you to look at paragraph 25 of the guidelines for some explanations about these different concepts of explicit agreement and acquiescence. Because another form of acquiescence is kind of explicit acquiescence where the parties agree that Frank is the supplier, I'm the buyer, and we agree that he can set certain conditions to which I will follow on later on. So I already hand him now certain responsibilities, which normally would be for me to execute. That, of course, is another form of having an agreement, although it is not the kind of normal agreement where parties sit together and say to each other, don't sell there and we put this on paper, or sell at least at price X. But if I give him the freedom to set the prices in my shop, then this is another way of agreeing on a pricing. So there is paragraph 25 in the guidelines may be interesting for these purposes.
So bottom line conclusion is, don't be blinded by just a formal document, go further. And as Luc explained, tacit acquiescence is quickly acquired. So that is very important. Make sure that in your daily practice, when dealing with your clients, you make sure that indeed you ask broader questions. We go back to our definition. So we have, in the meantime, an agreement to concerted practice. We know that that notion in definition is a chewing gum notion, very broad, can cover a lot. It has to be entered into between two or more undertakings that are the parties to the agreement. Now, we pulled out two or more, which in fact means the block exemption can perfectly well apply, and that was not the case in the 80s, perfectly well applied to tripartite agreements, whereby a producer has an agreement with an importer or a wholesaler and somebody active at the retail level, a three-party agreement, perfectly well coverable by the block exemption regulation. Two or more undertakings. I hope you have seen the notion of undertaking in previous courses, which means that if the agreement is concluded between two legal entities that are part of the same group, that we are not within the block exemption. We are in fact even not within Article 101 because we don't have two or more undertakings. That's the next slide. And Luke helps me and says, well, the notion of undertaking indeed is uncoupled from the notion of legal entity. The undertaking notion, which we find the definition, is the same as you find in competition law at large, and means every entity, could also be a physical person, engaged in an economic activity regardless of the status of the entity and the way in which it is financed, which means in practice that Luc as a physical person can be an undertaking. The only thing which is important is to see, does he engage in an economic activity on a given market? That means that the priest in your parish could be an undertaking if he engages in a commercial activity on a given market. That an architect or a lawyer is an undertaking. But also, and that is very important, that the notion of undertaking being uncoupled from the notion of legal entity covers also wider groups of legal entities that all are under the same control. And again, let's make it very practical. Just imagine that Luc and I are part of the same multinational, and Luc is active in Holland, I'm active in Belgium, and we enter into an agreement whereby I promise Luc that I will never sell a single set of glasses in Holland, and vice versa. Luc will not sell his glasses into Belgium. Is that a problem under Article 101? Is that a problem under our block assumption? No, because we have only one single undertaking. Luc and I, two separate legal entities, are part of the same group. We are the local importers in Holland and Belgium, part of the same group. We are a single undertaking, which means we can engage in market sharing. We could talk about prices. We could, in fact, fix prices if we want to do that. That is not covered. But keep in mind, important, going back to the slide, that this undertaking notion is a specific competition law notion that may be applicable to strange situations. Even a government could be an undertaking, depending on whether it meets the definition, i.e. engages in an economic activity on a given market. On this slide, we have one word that probably is going in future sessions going to be very interesting to follow, the notion of agency. Agency under competition law receives particular treatment. The key question with an agent is an agent, an entity, an undertaking separate from the principal? And we all know what an agent is in commercial law terms. I appoint Luc as my agent. He doesn't acquire the ownership of the glasses. He simply is looking for customers for me. He negotiates the deal, and then I transfer the ownership of my glasses right away to the customer that has been found by Luc. And the question is Luc an undertaking? And here we have to make a split. Luc, when he offers agency services to me, and maybe to other principals, is obviously an undertaking. He's obviously providing a certain degree of services on a market. And he says, Cuckoo, I can do this for you. I'm very good at finding customers. There is an undertaking. Where it really becomes interesting in this discussion is if I engage Luc in getting these transactions completed, what is then our relationship? And the rule is if Luc does not assume any risks in terms of costs or investments in that context, or only de minimis insignificant risks, Luc will be deemed part of my undertaking. There will be one single undertaking. Why is that important? Again, think about the classics, RPM, vertical price fixing. In that case, I can dictate to Luc which price he should be mentioning to the customer. If Luc assumes more than de minimis or insignificant risks or investments. I ask him to have a storage space, and he needs out of his own commission to engage in advertising campaigns for me and what have you. Well, then he takes risks, business risks. Then Luc will be deemed a separate undertaking also in that setting, and he will be treated under the block exemption as if he were a distributor. So agency is a fairly complex concept. Footnote here, and again, I will not bore you with that now, but we may want to deal with that later. The whole topic of agency is one which is currently heavily being debated in the preparation of the new block exemption regulation. And again, that is something we may want to discuss in some future sessions. Keep in mind that if you deal with agents, even though in commercial law terms the situation is obvious, that in competition law terms there is a level of complexity linked to this, depending on whether the agent can be deemed part of the same undertaking of the principal or will be deemed a separate entity and therefore a separate undertaking.
Yes, because that's something that we maybe should have said to you at the beginning of the session. Whatever we tell you here and whatever we teach you here may be different next year, because the current block exemption regulation expires in May next year. So before May next year, the Commission will have to adopt a new regulation. Now you can count on it that the new regulation will, in good part, stay the same as the current ones, because when we made the current one, of course, we thought very deeply, and it is a very good regulation. So therefore, there's only limited need for change. But I think it will stay by and large the same, but there will be differences. And so during these 3 sessions, we will try to indicate where most discussion is and in which areas you can expect changes to happen most likely. And where possible, we will already indicate in which direction we think they will go. But of course, it means that after you have done your exams, you will have another task, which is to follow the adoption of the new regulation and then get updated about what you have learned and what you should delete and what you should replace by the new regulation.
One of the things that I did not confer with Luc on that one, so he may start kicking me under the table. One of the things I think Valerie may want to keep in mind is that once we have definitive texts, that we organize a 1-hour session or so with this group, so at least we can give you the full update on where the Commission has landed. But this is a first topic, agency, where the debate is ongoing. Again, I don't want to, because I know we're shooting a lot of information in your direction, I don't want to overburden you. One of the areas where real debate is focusing upon is, one, how can a principal compensate for risks in order to bring it to the absence of risks level or de minimis level? The second area is, under what conditions will an agent who is also an independent distributor for the same supplier, under what sort of conditions can he still qualify as an agency that falls outside Article 101? That is where the debate is going. We will not preempt on where they will land, because I think, look, the debate is still ongoing, but that's a footnote we certainly would want to have here.
So, I mean, because practically, I mean, in the past, agents were often one-person entities. It was the person who would go around doors to sell insurances for an insurance company, and he would only work for one principal, and he would only sell insurances. What we see is an increasing demand from manufacturers to have agency also in other settings. So where a manufacturer who produces a whole gamma of products in the same product market wants to make a distributor an agent for only part of that gamma, for the most upmarket part, or for the newest models, or etc. And then the question is, to what extent should you take into account, or should you take care also of all the other costs that the distributor has for selling its full gamma? And that will be a discussion which we will not know now what the outcome is, but in the end, the question will be, when can you truly say that the agent is operating like a semi-employee and not anymore taking its own responsibilities and risks? And therefore, it's also logical that the principal can say what the agent should do. Because the difference is always, if I'm a manufacturer, Frank is my distributor, he takes his own risks, he has his own investments, then there's a limit to which it is logical that I should be able to tell him what to do. And there can be a competition issue, and I can use this to limit competition. The moment I pay all Frank's expenses, the moment I'm the one who takes the real risk, it's also fair that I can be the one who tells Frank what to do, at what price to sell and where to sell, etc. And therefore to have it outside 111. And it is on that continuum that this discussion is taking place.
It's like a nice thought that Luke will be paying all my expenses. I think that is something I'm going to sign up for.
Yes,
would be nice, Luke.
Frank, forget that you can ever be my agent.
Okay. Where are we in our definition? So the key definition for the block exemption, agreement concerning practice, you remember broad notion, 2 or more undertakings. For undertakings, you remember it's a concept different from legal entity. Agency is a particularity in that context. And also very important, the notion of undertaking would encompass several legal entities under the same control. That would be an intra-group setup that counts as a single undertaking. Right, that's where we are in the definition. What do these parties have to do to make us qualify as a vertical agreement? They would have to be active at a different level of the production or distribution chain. And that's pretty straightforward. Distribution, supply relationships, it's like this. We are not competing, both producing and then going into the market. No, our agreement is one which is like this, whereby indeed I produce and I supply to you, and you are going to be active at the next level. That is the concept.
Yes.
Maybe one quick question, if I may. This is Christian from Germany here. Earlier, you referred to the subcontracting notice. If in case it applies, we wouldn't be within the scope of Article 101. So how far would you regard its scope of application? I think you mentioned the example of a steering wheel. In my opinion and in my experience, it would rather be a very, very narrow scope. And even in most cases regarding a steering wheel, we wouldn't actually be within it. How far would you consider it, and what practical relevance do you see with regard to the subcontracting notice?
Christian, can we keep your question until we get to the part on IPR? Because that's exactly where we want to explain this. So what is the...
Yeah, sure, thank you.
What is the subcontracting notice? Why is it still there? And what are its limits?
Yeah.
Because that is where there's one point on the current slide which I want to add. It says the parties have to be active at a different level of the production or distribution chain. So it's vertical. But just before it, it says, for the purposes of the agreement, they must be at a different level. And that for the purposes of the agreement also explains that it is not only agreements between non-competitors which can be vertical, but also an agreement between competitors. If Frank and I are both brewers of beer, but I'm also a distributor of the beer, and I am offering my distribution services to Frank, then for the purposes of me buying Frank's beer for distribution, this is a vertical agreement. He is producing it, I'm distributing it. But of course, you can at the same time, at the brewing level, we are competitors. So for the purposes of the agreement, makes it possible to also cover vertical agreements between competitors. But then we will see later on that the rules are very specific for this situation.
Exactly. And then we go to the final bit of the definition. The agreement must relate to the conditions under which the parties may purchase, sell, or resell certain goods or services. In other words, a vertical agreement, let's roll it back, can deal with both goods and services, or just services. The content of the agreement must be the conditions under which the parties may purchase. So it could be a pure supply relationship. It doesn't have to be a distribution agreement. Purchase, sell, or resell means in fact supply relationships and distribution relationships. These two are being covered. If these conditions are met, we have a vertical agreement, and we have more or less our entry tickets for the block exemption. So in summary, agreement concerning practice, broad scope. two or more undertakings, specific technical notion under competition law. Operating, as Luc correctly pointed out, for the purpose of that particular agreement at a different level of the production or distribution chain, and the content must be the conditions under which the parties may purchase, sell, or resell certain goods or services. In other words, if we have a distribution agreement in which we have a section dealing with joint R&D, well, that part is not dealing with the conditions under which the parties may sell or resell. It has to do with joint R&D. So that section, that part of your agreement will never be covered by the block exemption.
Okay, this is a good moment to have a break. Perfectly on time, I would say, to Valerie, if she was still there. 1 hour. I think it was the.
How much do we take?
We take 10 minutes, not more. So
Yeah.
we see you
Perfect.
back in 20 before 3. Yeah, 14:40.
Thank
Okay.
you.
Ja, ik zag hem al.
Ja,
Ik zag hem al.
ja, precies.
Hier, maar je klikt nu weg.
I muted you.
Okay.
You muted us. Okay, we did this also ourselves, I think at the same time. Ja, ik heb het pakken. Ik heb een kopje ergens nog. Ik was iemand die altijd zo'n kopje. Okay, let's start again. Open your cameras again, except for Julie, who we understand you don't have access to a camera at the moment. And let's go on.
Right. The first point we ticked off was, when do we have a vertical agreement? I will not repeat what we discussed. If you have questions, you know where to find us. The second question, of course, that's an important one, in order to make sure that we need to use the block exemption, is whether we are dealing with what is called an appreciable restriction of competition. If we don't have that, we typically are outside Article 1011. We therefore don't need the 1013 exemption, and therefore we don't need to look at the block exemption. So the key question will be, when are we dealing with an appreciable restriction of competition? And here, and I hope that that is something which you have seen in previous courses, we have to make a distinction. I'm going to see whether I'm going to get my slides in proper order. It's here where the de minimis notice pops in. An agreement of undertakings must have the object or effect of perceptibly restricting competition in the common market in order to be covered by Article 1011 and to bring us in the need of having an exemption. And then the question is, where does this de minimis thing fits in? You already heard about the de minimis notice. In order to make sure that we do that right, we have to make a distinction between what is called an infringement by object and an infringement by effect. Let's first go to the infringement by object. And there we have a case, I'm not going to read this out loud, the Expedia case from the court, where the court basically has said, and I give you a shorthand, if indeed a particular restriction or agreement has an effect on trade between member states, and the restriction is an object restriction, well, in that case, there is no further work to be done in terms of measuring appreciability. We assume that an object restriction is appreciable. Let me turn it around as a lawyer. If I'm confronted with an object restriction, I will no longer be able to use the lack of appreciability as an excuse in order to bring that restriction outside Article 1011. Object restrictions are presumed to be appreciable.
The area of by object is one of my favorite topics to talk about. And I would want to refer you to the article which is in the literature list, and which I think it may also have been handed out to you by Valerie, or which is on the website available at least, that I wrote, defining by object restrictions. Because, to be honest, I think the debate about what is a by object restriction has been a bit confused over the years, and also the case law is not completely clear, one could say, as the minimum. The debate and also the definitions of what is by object have the tendency to focus on the potential to have negative effects. And it sounds logical because you think, okay, something is by object is a serious restriction of competition if it has serious effects. But it doesn't make too much sense if you think about it, because basically every restriction can have negative effects. And at the same time, we don't call them all by object. So to give you an example, I mean, a price cartel where competitors agree on a price is seen as a by object restriction. If those same competitors start a joint venture, produce together, and of course, then also price together, this is not seen as a by object restriction. While in both cases, they can agree on the price for the products sold on the market, and they could have, in principle, the same negative effect on the market. They're the same about in verticals. Resale price maintenance, fixing a vertical price for your distributor is a hardcore and by object restriction. While non-compete, telling your distributor not to sell competing products, this can of course also have an effect on competition, a negative effect, is not seen as a by object restriction. And I think, why is that? So, I mean, it can't be only the potential to have negative effects, therefore. And in that discussion, we then see that there's sometimes a pitfall that people say, you have to look also at the intentions. So if you see bad intentions, if you see parties getting together and agreeing that let's harm the consumers, let's increase our profits and harm the consumers, combined with a negative effect, that should be by object. But also that does not make too much sense, because the same restrictions can be used with good and with bad intentions. So then you would have a by object definition, which is not clear cut in the sense that a price cartel is always by object, but it depends on the intentions that were there when the price cartel was formed, which of course doesn't make sense. At the same time, it doesn't make sense because you have to look at the effects before you can classify it as by object, which goes against the whole purpose of the distinction between by object and by effect, because the whole nice part of a by object definition is that you as an authority, you can just presume the negative effects. You can even presume that it always has appreciable restriction of competition as its consequence. And therefore, I always say to people, if you really want to make sense of by object, and the court case law, I think, is slowly recognizing this, although it goes quite slow, is that what really defines by object is not just the potential to have negative effects, but more the lack of potential to create efficiencies, the lack of potential, the absence of potential to create positive effects. I mean, why do we call a price cartel a by object restriction? Because if competitors get together simply to increase the prices, you immediately see there is no potential to create efficiencies. They do nothing together, they just increase the price. If at the same time those same competitors get together to form a joint venture and produce together, they put together their capacities to produce, they therefore may be able to produce better. You immediately see the potential for efficiencies of a joint venture. It may also have the negative effect of increasing prices if it's the only supplier on the market, if all producers on the market decide to only produce through the joint venture. But at the same time, there is the potential to create efficiencies, and it is not by object. And therefore, it is essential to realize that what really defines by object is the absence or the low likelihood of creating positive effects. And the case law, as I said, in carte bancaire and later case law is slowly going into that direction. And I think if you read the definition of Expedia, it makes sense to say there's no question about appreciability. It is always assumed to be appreciable in its anti-competitive effect, only because you don't expect efficiencies. Because if you don't expect efficiencies, then the only reason for the parties to do the restriction is to create a negative effect. And the only way to do so is if they have sufficient market power. And therefore, it will always be appreciable. Think about the price cartel again. If Frank and I start to collude and say, let's join forces and let's make sure that we ask a higher price for our services on the market of legal or competition policy advice. Because we are too small, the two of us, in the whole market of all people who know about competition law, and we increase our prices, we will just lose customers, and we will just be wiped out by our competitors who also offer services on the market. So the only reason for us to do so is if we are able to be sufficiently important on the market to make sure that we don't lose too much to our rivals. So it might be because we really are important on the market of giving competitional advice. For example, we are the only two who really know about vertical agreements. Therefore, we can say we increase our prices if we compete less between us. The alternative is that Frank and I are just have a bit of a bloated self-image. We have too big an ego. We think too much of ourselves. We increase the prices through our price cartel, and we simply lose market share. And if you prohibit that agreement, nothing bad happens to the consumers. So it's either you protect the consumers against a real increase in prices, or the prohibition is not destroying any efficiencies, because there were no efficiencies. And that's why I think the essence of by object in the end should be found in the lack of the potential to create efficiency. So later on in the course, when we're going through the by object or hardcore restrictions in the vertical block assumption regulation, I'll try to explain to you why there is for those restrictions a lack of potential to create efficiencies.
Right. Let me take a step back. We need in our vertical agreements an appreciable restriction of competition. That can take two forms, and I'm offering you the content here in Lego block format. Either it's an infringement by object or an infringement by effect. What we know is that the thinking behind the notion of by object, as Luc explained, and we also know, thanks to Expedia, that we should not come up with an appreciability or lack of appreciability defense in order to get something outside Article 1011. It will be, if it's by object, it is appreciable. Now, and Luc is already hinting at that, but I'm going to give you that because it will help you, and we're going to repeat that because it's very important. In the vertical world, and I know that we could do theoretically about it, but in the vertical world, the by object restrictions are, as Luc mentioned, the restrictions mentioned in Article 4, the hardcore list of the block exemption. In other words, if you ever get a question, the vertical agreement, what would be an object restriction? Don't start dreaming. It's the list of Article 4. And the court may indeed in the future add something. We'll find out. But for present purposes, it's Article 4. In a nutshell, what is Article 4? RPM. It will be territorial limitations and customer limitations, with few exceptions. We're going to discuss them in the next session. That is by object. By effect is, simple definition, all the rest. And for all the rest, which is not on the Article 4 list, I can make an appreciability or a lack of appreciability argument, stating, hey, there may be a restriction of competition, but it's not appreciable. And therefore, it's not an Article 101 problem, and therefore I don't need the block exemption. Here we have the de minimis notice, which gives us concrete figures in a vertical context for distribution agreements for the by effect restrictions, i.e. those not qualifying as by object, dus all the rest compared to what's in Article 4 list. The market share should not be in excess of 15%, both for the supplier and for the distributor on all the relevant markets that are relevant to my agreement. In case we have cumulative foreclosure effect, take an example, the entire market is working with quantitative selective distribution, and we'll discuss what that means in practice in the next session. All of them are using the same standard distribution format, the same type of restrictions, the same type of contracts. Well, in that case, if you want to make a de minimis argument for by effect restrictions, your market share limit goes down from 15% to 5%. A typical application, for instance, in the car business, where everybody was more or less copying each other's contracts, the Commission has almost consistently been applying a 5% limit instead of a 15% limit in order to define those players in the market that could make use of the de minimis notice.
That does not mean that if you go above 50%, respectively 5%, that you are automatically having appreciable anti-competitive effects and you automatically fall within Article 1011. No, that still has to be seen. So it's still then for the authority to show why with your more than 15% or your more than 5%, you are contributing appreciably to a demonstrable anti-competitive effect. It only means that below 15% or up to 50% and up to 5%, you can count on not being found to be appreciable. You have the benefit of the block of the notice, and you have the benefit therefore that the Commission has said, here we will normally apply the assumption of non-appreciability. And that of course is a big advantage, because then you can say, whatever I do in this area of effects type restrictions, I'm falling outside Article 111, and I have no risk of no limits on what I can do, etc.
And on this slide, very quickly, to give you a bit of a surprising result maybe of that logic, you heard me say RPM, vertical price fixing, territorial limitations, customer limitations are on the Article 4 list, therefore by object. A number of usual suspects, and I think Luc already mentioned them when he was discussing the economic effects, like a non-compete obligation is not on the list. A tying obligation is not on the list. So it would be a by effects restriction. And for those restrictions, you can work with a de minimis argument, lack of appreciability, different, of course, from the examples you see in the red ribbon, vertical price fixing and export bans. So that is our step number 2. So we have a vertical agreement with appreciable restrictions of competition. If they're appreciable, then we can start looking at a block exemption, because we are in the Article 101 prohibition. We need an exemption, and we want to use the block exemption to achieve that. The block exemption is linked to certain market share limits. The market share limit is set at 30%. Could be slight variations, but 30% is the limit set in the block exemption. How do we measure that? It's a double limitation. It's a limitation applicable to the supplier and a limitation applicable to the purchaser, the buyer, the one who's acting downstream. For the supplier, we're going to look at the market where the supplier is selling the goods or services to the purchaser. And for the purchaser, we're not going to look at the downstream market. We're going to look at the purchasing market. In other words, the market where the purchaser is purchasing the goods. Let me become extremely concrete, otherwise it may be confusing. Just imagine that my name is Nike and I produce sport shoes. And I would want to find out whether my agreements, my distribution agreements, are covered by the block exemption, and in particular whether they are under the market share limit of 30%. What do I do? As Nike, I'm going to look at my market share as a supplier on the market where I'm selling these products to my purchasers. And of course, I'm just looking at my market share, my Nike shoes. You are my distributor, but you're a very good one, and you just don't attract only Nike, but also Adidas and Puma. And we're going to see on the purchasing market where you are buying from Adidas, Nike, and Puma, what is your share as a purchaser of that market? If that share is below 30%, we are within the limitations of the block exemption, i.e. the market share limit is not trespassed, and we are within the scope of application of the block exemption. Maybe Luc, you want to add something on?
Yes, I mean, because we have made some choices, as you can see here. And one is, why use a market share threshold to cap the application of the block exemption? And basically because, as I said, it's economic policy. We wanted to make sure that we were only covering agreements where we could assume that the negative effects were either absent or were so small that they would normally be outweighed by potential efficiencies. And the market share is basically the best indicator that we have of market power. As we said, I mean, you need a level of market power to have negative effects. Therefore, it made sense to make a market share cap in terms to use that one to make a cap on the coverage of the block exemption. Because the logic is, if you are having a 70% market share or 90% market share, and you are telling as a brewer to your pubs not to buy from competitors, this is much more likely to have a negative effect on the possibilities of the competing beer brands to sell on the market. Well, if I have a market share of 20% or 30%, there is much less possibility to have a big negative effect on the market for the competing beer brands, because there's still 70% of pubs who are available for other brands. Now, of course, the cap itself, the 30%, that's not exact science. That is a combination of experience, and you could go lower or higher, but that is where we ended up. So, but the logic is a bit de minimis, up to 50%. We normally presume there will be no effects, and between 15 and 30%. There may be negative effects, but they will not be so big. And if they are there, we can normally assume that efficiencies will outweigh. That may, of course, be a bit too cautious. Some would say you should go higher. But at the same time, the answer of the authority will be, yeah, but there's no presumption of Article 111 above 30%. There's no presumption that your restrictions will be anti-competitive. It's just that we cannot give you a safe harbor. It is also possibly too low, possibly too high, some would say, because 30% is already a third of the market. And if Frank and I are both brewers and we are both having 25% and we both tie our pubs, then we are already collectively tying half of the pubs in the market. But that's why there's the instrument of withdrawal of the block assumption. So there's a safe harbor, but it can be withdrawn below the 30%. What is, I think, is not really questioned is why we look at the supplier's market share downstream. Everyone understands if you want to look at the market power of a party in the market, you want to look at its power to harm its consumers. And how do you do that? You look at the position towards its purchasers, towards its customers, which is the market share on the selling market. The real surprising part is that for the purchasers, for the buyer, we don't use the buyer's market share downstream, but we use the buyer's market share upstream, the market share on the purchase market. So why that choice? Because you would think also for a buyer in a vertical relationship, what indicates best its potential to harm downstream its customers, it's its market share downstream and not its purchasing market share. But there were a number of practical reasons why we chose to go for the buyer's upstream market share. And the most important one was it simplifies the system. Because the moment that, in the example of Frank, Nike and its distributors, the only thing they have to look at is the market of sports shoes between Nike and the distributors. How much is Nike selling to the distributor and how much is the distributor buying upstream on that same market? The moment that you want to look at the buyer's downstream market share, then you have two problems. One is there may be multiple markets on which the buyer is active downstream. So you may have to look at the market share not just on one market between the two parties, but on a lot of markets. The distributor may be active on a number of local markets or regional markets. And the second problem is that the upstream manufacturer, the supplier, has less view of what goes on the downstream markets. So he may have less information about and less possibilities to check whether what the buyer tells him the market share is on the downstream market is credible or not. And that means that you create a kind of hold-up problem or a kind of problem for the parties to get to an agreement, because I, as a supplier, I may not want that my buyer tells me, oh, no problem, I'm below 30% and we are covered by the block exemption. To later, if it somehow is convenient for him because he wants to get rid of the contract or wants to change something, comes back and says, oh, sorry, I think it's much more than that. So therefore, that is one possible, that was the practical side. And then we looked at how much do we miss by looking at the purchasing market share. Now, often there is a link between how much a company purchases upstream and how much it is selling downstream. So in that sense, the purchasing market share may be a good indication of the downstream market share in the first place. So in that sense, we don't miss too much. We might even sometimes gain something because there are situations where a high market share downstream may not mean that I can use my supply relationship to have a negative effect. So to give you the example, let's say that I am a manufacturer of bicycles and I am purchasing steel from Frank. So our vertical agreement is Frank sells steel tubes to me, the bicycle manufacturer. I may be big as a manufacturer of bicycles. I may have a high market share in the bicycle market. But does this really give me a possibility to do something harmful to competition on the market of steel tubes? Frank is selling steel tubes not only to me, but to many others, people who make other machines, other types of instruments, not just bicycles. The market of steel tubes is much wider than the market of steel tubes for bicycles. And therefore, the possibility of me to say, for example, to Frank, I only want you to buy your steel tubes if you only sell them to me and not to my rival bicycle manufacturers, is very small, because Frank or his rivals who also sell steel tubes will easily find possibilities to sell to these other bicycle manufacturers. So the possibility for me to foreclose my rival bicycle manufacturers to use my vertical agreement with Frank to do something harmful to competition may not be very big, even though I am very big on the bicycle market. So sometimes the high market share downstream may give the wrong indication. Of course, you could also say that it may also be the other way around. That's true. I mean, but at least, I mean, let's say that I am a sugar producer and I'm buying sugar beet from Frank. And I may be the only one who produces sugar with sugar beet. So I am very big in the sugar beet buying. But on the downside, selling sugar, I'm very small, because most sugar that is being produced comes from sugar cane. And therefore, my possibility to harm competition downstream and to harm purchases of sugar is very small. In that sense, in that case, my high market share on the purchase market excludes me from the block assumption for no good reason. So it can work both ways, but at least there are also many situations like the bicycle manufacturer. And there's only one area where I think the choice that was made has potential negative effects. And that is where the upstream market is much wider than the downstream market. So think, for example, of local and regional retail markets, national or European supply markets of products to supermarkets. I may be a supermarket chain in Finland who has a very high market share in Finland. So for the producers of coffee and chocolate bars and whatever else, I'm an important access to the Finnish market. And at the same time, my purchasing of coffee and chocolate bars on the European market, where me and other supermarket chains are buying, my market share may be very small. That situation, my purchase market share may be small, I may be covered by the block assumption. And while at the same time, my access point to the Finnish market may be so important that it allows me to require from the suppliers of chocolate bars and peanuts and whatever else to say, for example, only supply to me and not to my rival, the few rival supermarket chains in Finland. It's that constellation where the current choice may have some drawbacks, and where, if any, there might be a need to look at the need to withdraw the block exemption because the market share threshold is seen too high. But for the rest, the practical advantages of having only to look at the upstream market between supplier and buyer, for us, outweighed the negative effects of making this choice.
So where are we in our exercise to see to what extent our vertical agreement can be covered by the block exemptions within the scope of application? We have a vertical agreement, point 1. We know there are appreciable restrictions of competition. Remember object effects. 3, in the meantime, we established that we are below the 30% market share threshold, and you retain it's a double threshold, supplier, buyer, and basically on the same market, selling market, purchasing market. It's being measured. The 4th point we're going to discuss is what if our vertical agreement, our distribution agreement, for instance, would contain intellectual property rights? It could be access to a patent, could be a trademark, could be commercial know-how. What happens if that is in there? And again, there's a lot of content on this slide, so bear with me. I'm going to take you through it one by one. The block exemption only applies in the hypothesis where the IPR is handed over by the supplier to the purchaser, and not the other way around. And we'll come back to that in a second. That ties in with our subcontracting notice discussion, which I think Christian was raising. So this will be the point where we're going to address this question. Second condition is the IPR may not be the primary object of the agreement. Just imagine my name is Coca-Cola and I give you a supply contract whereby I supply very cheap white t-shirts to you, and I say, hey, you can put my Coca-Cola brand name on these t-shirts and start selling them. And let's be honest, the focal point of that agreement is not the supply of t-shirts. The focal point of that agreement is to get you access to the use of the brand name Coca-Cola. In that case, the primary object of the agreement is a trademark license, is not the supply of goods or services. Third point is the IPRs that are injected in our vertical agreement must be directly related to the use, the sale or resale of goods or services. Typical example, I give you access to my brand name in order to make publicity for the sale of my goods. Would be a very good example. Or I give you access to a use patent, for instance, because you need it to be able to perform certain services that are linked to the supply of the products. It must be directly related to the use, sale, or resale. So the fact that we have a distribution agreement and unrelated to that, I give you the right to use a brand name for something completely different, puts that part of the agreement outside the block exemption. And finally, that's a bit of a catch-all. You cannot be clever. And clever means that you cannot use the IPRs to achieve something under the block exemption that you could not do straight away. Let me be much more practical. Just imagine, I give you a trademark license for my Coca-Cola brand name, but just for Belgium. And you are not allowed to use that brand name when you start shipping the product across the border. Well, that would be, in fact, a sort of an indirect export ban. And the export ban is, as we will see on our hardcore list, the fact that I'm not having a straightforward export ban in my contract, but I think I'm clever by organizing it through the limitation of the IPRs will not help me. In that case, the restriction has in fact the same object of something which is on the hardcore list. These are the 4 conditions that you will need to check to see to what extent the presence of IPR, intellectual property rights, in your vertical agreement are a showstopper or not a showstopper to the application of the block exemption. And then look, I think we may want to dive into the subcontracting notice because that's indeed and we still have Christian on the screen here. So Christian, this is your question, your time.
Yes, so I mean, and to answer that question, Christian, I will start with saying that the limitations on the coverage of the intellectual property rights, as just explained by Frank, is not because the aim is to be stricter in the cases that are not covered, so the things that are falling outside the block exemption regulation, is often the opposite. It is because the vertical block assumption regulation should only apply to things which are in that sense similar. That means normal vertical agreements to sell, purchase, and resell. And if you have the licensing of IPRs, there may be good reasons to be more lenient in the assessment. So you don't want to apply the same block assumption regulation and the same limits to its coverage and the same hardcore list. Now you may want to apply, and one wants to apply in competition law, in general, a more lenient policy. That is why we have for licensing the transfer of technology block assumption regulation, which I think comes in later sessions in this course. And if you look at the transfer of technology block assumption regulations, and that is not just because at the time I wrote that regulation, you will see it is very much the same as the verticals. It's not because I just was lazy and used the same text, but it's very much the same in the sense that you have the same questions. It's either licensing between competitors or between non-competitors. If it's between non-competitors, you have the same type of potential anti-competitive effects, and therefore you see the same logic in the vertical part of the TTBR as in the vertical block assumption regulation, with the exception that the TTBR is just a bit more lenient. So it is a bit more allowing things, the type of resale restrictions that are not hardcore is a bit wider, etc. The same logic is for the block assumption not to cover renting agreements. I mean, it is about sale and resale of goods and services, not about renting. And that's also logical, because if I sell you my house, you would be surprised if I tell you you can't resell it or you can't use it to have a bed and breakfast in it or whatever. And there might even be an anti-competitive element in it if I tell you this. But if I rent you my house, it's quite normal that you can't resell it because it's not your owner, you're not the owner. But it's also quite normal that I tell you not to only use it as a family home, but not as a bed and breakfast. So all kinds of conditions which are quite normal in renting should not be certainly fall under the vertical rules and possibly be a hardcore restriction because I'm telling you that you can't resell or whatever else. And now I get to the subcontracting. That's exactly the same for the subcontracting. So what happens in subcontracting? In subcontracting, the transfer of the license is not from supplier to purchaser, like we have in franchising. And franchising we wanted to cover with the vertical rules. In franchising, the franchisor says to the franchisees, I sell you my products, my wedding dresses or whatever, and I also give you my method of selling wedding dresses, in which there's IPR and know-how. And this combination of the products and the dresses together and the IPRs is a vertical relationship. And it's covered by the block assumption as long as the main part is the goods and services being sold. But it's different when it goes the other way around. And that is where the subcontract notice comes in. But you have, as Frank said, you have situations where I want a particular component being made for me, and I look for someone who's able to produce it for me. And this upstream producer of this component for me is my subcontractor. And what the subcontract notice says is, if I provide IPRs to the subcontractor, which enable the subcontractor to supply me this particular component. So if I had not given him this IPR, this know-how, this patent, whatever else, then the subcontractor would not have been able to supply to me this particular component. In that situation, it falls outside 1.1 if I require the subcontractor to only supply it to me. And the logic, of course, is that if I supply know-how which enables the subcontractor to produce for me, but he might at the same time start to produce for my rival Frank, then I might not want to provide him the know-how in the first place. So in order to incentivize me to provide and to find an efficient solution and to find an upstream subcontractor and to provide to the subcontractor the necessary know-how and knowledge and IPRs, which allows him to sell to me or to produce for me, it falls outside 111. It is not anti-competitive if I tell this particular subcontractor, now what you produce with my know-how is only for me. And that is why that particular thing then falls outside 111 and should not be covered by the verticals, because then it might fall into the same issues as that it might be seen as a factor restriction and that is only covered up to 30%, and above 30% it becomes in the area where it is an individual assessment that needs to be done. No, here, no matter whether you have 10%, 20% or 80% of the market, the moment that your subcontractor can only make this component because you give the know-how, because you give the IPRs, then exclusive supply falls outside Article 111. So I hope that also answered your question, Christian.
Yeah, thank you. And maybe just one short follow-up. So the requirement that the know-how must have enabled the other party to actually perform the contractual services, I imagine you would consider this requirement as rather strict. So not any kind of know-how that you provide to your subcontractor will guide you in that direction, right? Because otherwise this would be a really easy way out of Article 101.
Indeed. I mean, enabling must mean that it is commercially and economically, the upstream subcontractor would not, it wouldn't be possible for him commercially and economically to produce those products at the prices at which and the cost at which it enables him to become the subcontractor for the downstream buyer.
And the logic really is, Christian, that absent that supply of IPR, your subcontractor simply would not be a market participant that is able to bring these components, for instance, to the market. This raises, and we're not going to bore the entire group, but this raises interesting and very complex questions, because now we're talking about a simple case whereby you give indeed an IP license. But what if I, as the customer of the subcontractor, start paying for the tooling, for instance, and otherwise the subcontractor would not be able to buy that tooling because it's too expensive. So subcontracting raises a lot of interesting questions, and interesting to see how far you can take a subcontracting notice to justify that the exclusive supply back obligation, you subcontractor will only supply what you make to me, to how far you can drive that. But that's a separate topic, yes, which we want to develop on at a later stage.
Yes, but the most important point to remember is that the limitations should never be understood as meaning, if you therefore do not fall under the block assumption regulation, there's something fishy and something problematic. No, it may be the opposite. It may be because there are reasons to treat it more leniently.
We continue in our shopping list. We have vertical agreement, appreciable restricted competition. We're sure not to exceed 30%. We have checked the 4 boxes for our IPR, and we're safe. And then we come to the 5th one. We were mentioning that it is possible, given the definition of vertical agreement, that agreement is entered into between competitors. How does that function when there is a competitive relationship and the interaction of that with the application of the block exemption? And there we have specific rules, and I think Luc, you were already hinting at them in Article 2, paragraph 4 of the block exemption. There is indeed an exception for vertical relationships entered into between competitors, an exception that makes these agreements fall within the block exemption. What is the exception? And we'll focus on the one for goods. There's a similar one for services. For goods, the exception applies in case a supplier is a manufacturer, a producer of goods, at the same time also a distributor downstream. And at that level, he is in competition with his purchaser, who is also selling downstream, but is not competing at the production level. In other words, he is not producing. Let's make it very, very plain. I'm a producer of cups, and I have a number of shops where I'm wholly owned, where I sell my cups. Voila. So it means I'm a producer, but I'm also active downstream, and I'm trying to sell these cups through my shops to consumers like Luc. In addition, I have also independent distributors or shops to whom I supply these cups. And they, of course, are competing with my shops. That is what we call a situation of dual distribution that meets the exception that allows competitive relationships in a vertical sphere to be covered by the block exemption. Again, a footnote, there is a big debate going on as to what in the future regulation should happen to dual distribution. We're not going to bother you with that, Luc, because it's not very clear how this will end. A lot of criticism on the initial proposals that were launched by the Commission from various angles. I think they're reconsidering looking at it, but at a later point in time when things become clearer, we may want to revert to this. Or if we have a quick separate session where we enlighten you about a new instrument, we may want to discuss this. So keep in mind, this, apart from agency, is a sort of second area where a lot of debate is going on as to the widening of the exception, and at the same time, adding additional limitations on the possibility to benefit from this exception. I say no more because, as I said, things are still in the works.
Yes, I mean, firstly, I mean, as an economist, but when I got involved in making those rules, I was first surprised, but I also learned to appreciate the legal technique which you see here, which is you first have a definition of vertical agreements, which says, for the purposes of the agreement between parties who are not at the same level. So it captures also all vertical agreements between competitors. And then the later article says, the exceptions are not applied to vertical agreements entered into between competing undertakings. So then it's thrown out again. And then it says, except for the following. So which brings a part again back in. And the logic there, I think, is you first make it possible that things are being covered so that you don't miss what you may want to cover. Then you exclude it in general, and then you include what you want to include. And that is a very nice way to make sure that you don't include too much and not by chance excludes things which should not have been excluded. So that's one. Secondly, I mean, why is this covered? Why is dual distribution covered with the current conditions of Article 2.4? I think it is because experience that we had over the years showed us that what is quite normal is a manufacturer who also has a certain presence downstream at the distribution level. But that is often a very small presence, but it may have it for several reasons. Historical, it may want to find out what goes on in the market, may want to have direct customer relation contacts and thereby finding out how things are being appreciated. So what you see is that a lot of manufacturers have a flagship store for selling their own products, in addition to a much wider distribution network, a brewer who has some pubs itself, etc. Our experience was that because of the size of the investments, if you really want to be big on the retail markets, being very big, because retailing means stores, personnel, property, all that, the overlap at the retail market, the overlap where they were competing with their buyers, was normally very small, and therefore the loss of competition between the manufacturer and the independent distributors at the distribution level was not very important. If you think about the brewer and the pubs, the loss of competition between the pubs owned by the brewer and the independent pubs was normally not the issue that those vertical agreements were asking for authorities to be looked at. The normal things that were always on the table were the non-compete, the foreclosure of other brewers, etc. Those were the issues of competition that were being looked at. And therefore, our experience was that we can cover because the real issues are not loss of competition between the parties, i.e. horizontal, i.e. should be for the horizontal rules. No, the real issue is loss of competition potentially at one of the two levels with third parties. Now you understand that is very different for if the same would apply to dual distribution at the intermediate product level. Think of a car manufacturer, Volkswagen, selling engines to Peugeot and putting conditions in the agreement with Peugeot about how the engines can be used. The first and intuitive thing that you would want to investigate is what does this mean for competition between Volkswagen and Peugeot on the car market. I.e. the first concern that you have is the horizontal concern of loss of competition between the parties. That is the horizontal question, which you don't want to deal with under the vertical rules, because the vertical rules in principle are not looking at competition between the parties. It's always about loss of competition with third parties, the upstream foreclosure, the downstream foreclosure, the collusion upstream, etc. So I think that is why the current rules are as they are. And the question now is, will the review change that? And as Frank said, I mean, if you looked at the, if you would have looked at the proposals by the Commission of when was it? This spring, July. There were many things in there which probably won't last and which will change again, etc. There's one element which I think will remain, which is the Commission, I think, rightly spotted that at the area of the distribution level, there's one development which is changing the picture of dual distribution fundamentally, which is the rise of online platforms. The online platforms started out as either like eBay being an online provider of services to others who wanted to sell things on the platform. So they were like a marketplace, they were just offering the service for others to sell their goods. Or they started like Amazon as an online distributor of goods that they were selling themselves. But what you see, both types of platforms have come to the middle where they are at the same time selling their own goods and at the same time being the host and offer platform services to independent distributors who sell goods often in competition with the platform goods itself on that platform. So what you see now, let's say on Amazon, you see Amazon itself selling sports shoes as Amazon online distributor. At the same time, there are independent distributors making use of the Amazon platform to also distribute sports shoes. And that is not anymore of a size where we can assume that the overlap is not very important. That the potential loss of competition between Amazon as a distributor and the independent distributors at the distribution level is negligible, and therefore it should only be seen as a vertical agreement where Amazon supplies platform services to those independent distributors. So I think on that area, no matter what comes out, they will have to find a solution whether and how to cover this under the vertical rules or to exclude it from the vertical rules, because it's obvious that this is not merely vertical anymore.
May I come back to your example from the automotive industry with Volkswagen and Peugeot? So what exactly, in your opinion, would be the legal basis to analyze this case? Only the horizontal guidelines, or do you see any applicability of other horizontal block exemptions here? If there is no particular research and development involved or IP licensing, but rather just supplying these engines, then you're in the horizontal guidelines, right?
Yes, then it is horizontal guidelines, and then the horizontal guidelines might at some places they also do say then the horizontal guidelines look at to what extent this type of supply and purchase relationships might limit competition between the competitors. And they then sometimes say, and in addition, as a next step, you may want to look at the verticals to see whether there are also vertical issues. But the first step here would be to look at the horizontal guidelines and look at the assessment under the horizontal guidelines as to what is the effect on competition at the market where they compete.
You might maybe, Christian, also want to check the specialization block exemption. I heard in your example that there would be no R&D, so the R&D one is out. In the horizontal sphere, we have two block exemptions essentially, which are purely dealing with or dealing with horizontal relationships. That is the R&D one, specialization. Maybe in the Volkswagen Peugeot example, there might be potential for the 1217 for that block exemption to be checked. There, of course, the market share limit is lower than 30%.
Yes.
So it's either that specialization block exemption, or it would be horizontal guidelines where you have a sectional joint production.
Yeah, but the specialization is also part of the horizontal rules, and part of it's also further explained in the horizontal block exemption regulation. So it's anyhow the horizontal guidelines. Sorry.
Yeah. Is that sufficient to address your question, Christian?
Thank you.
Let's move on. We're almost through our shopping list to see whether we can make our vertical agreement land within the scope of application of our block exemption. We just touched upon the competing or non-competing nature of the parties to the agreement, and there you retain that it's only dual distribution, whereby the competition takes place downstream, that is covered by the block exemption if there is competition taking place upstream, and typically the block exemption would not be applicable. The final point you would need to check is to what extent does the particular configuration we're dealing with may land in another block exemption. And there the rule is fairly straightforward. It's unimportant whether your agreement would be covered by that block exemption, i.e. meet all of the conditions of a block exemption and not contain any hardcores, for instance. The key question here is, would your agreement fall within the scope of application? And if that happens, that will be sufficient. You know, we only have a handful of block exemptions left. We have the vertical one, we have the automotive one. Automotive one will be a typical one whereby you say, well, there is a specific block exemption on automotive. For the moment that your dealer agreement falls within the scope allocation of that one, on account of this rule, our general block exemption would not be applicable. And the other ones, I think Luc mentioned them already, technology transfer block exemption regulation. So if there's a real licensing going on, well, in that case, maybe 316, that block exemption would be applicable. And that would then indeed rule out the application of our general vertical block exemption. And two other ones are our joint R&D and specialization. Again, just look at the scope application. Does your agreement land in that block exemption? Well, in the scope application, then in that case, look at that one and not at the general vertical block exemption.
Yeah. And that is, I think, mainly relevant for the transfer of technology block exemption regulation, because the verticals says if the main aim of the agreement is not the transfer of technology, but it's the sale of goods, that the verticals do apply. But the tech transfer rule and the tech transfer block exemption regulation applies not only when the main aim is to transfer technology, but also when it is not the main aim. And therefore, there is a certain overlap between the two. So where the overlap does occur, where the TTBR is applicable, it means that TTBR is the one that takes precedent and not the vertical block exemption regulation.
And TTBR, unless it's familiar to everybody, is the technology transfer block exemption regulation, 316.
Yeah.
Voila, we've done our homework here on the conditions of application. Maybe a quick pause for 1 second. Is there anything in terms of what we discussed, the sort of tick the box you would have to do to see whether your vertical agreement lands within the scope of application? Anything left in terms of open questions where we were unclear or you would like us to expand? If nobody has questions, that means that we've been extremely clear today, which is exceptional.
No, not so exceptional, but anyhow, it brings us to a next pause.
Yeah, it's 3:45. Shall we take again a 10-minute break? And
it's 15:40. So 15:40, 10 minutes We see you back at 10 to 4.
Yep.
5 to 4, Frank says. God, he is always too nice.
Is
5 to 4.
5 to 4.
Welcome back. I hope you can hear us. Yeah, okay, good. So we've landed on the left side with our application conditions. We're going to the right side of this slide. And there you see two types of restrictions, which are the core of our block exemption. The hardcore restrictions and the exclude restrictions. We're going to have a deep dive into these restrictions in next session. So what you get now is a sort of first flavor of what we're talking about. Let's first look at the hardcore restrictions. The famous Article 4. Remember, this is the list of object restrictions we were discussing. The vertical guidelines, I switch right away, you get these slides to the next slide because they summarize what was in the quote from the vertical guidelines. First of all, if you include a hardcore restriction in your vertical agreement, you lose the benefits of the block exemption for your entire agreement. One mistake, one vertical price fixing clause, one export ban is sufficient to deprive you of the benefits of the block exemption for your entire agreement. In case of self-assessment, which would then be the next best because you are no longer covered by the block exemption, self-assessment meaning you're going to individually check to what extent the four conditions of 1013 are met. In that case, you are confronted with a negative presumption that the agreement will probably fall outside Article 1013. In other words, a negative presumption that you can meet individually the conditions of Article 1013. It becomes an uphill battle to complete that self-assessment. That are the three key consequences of the hardcore restrictions. And here you have very quickly on the slide an overview of what we're going to discuss next time in more detail. What are the hardcore restrictions? What will you read in Article 4? Vertical price fixing, and again, what it exactly contains will be explained to you in the next session. Territorial and custom restrictions, and again, just to get your minds going for the next session, you'll see that a basic distinction to be made in that debate is the one between selective distribution and non-selective distribution. And again, a second distinction is the one between active and passive selling. I toss these notions in your direction for a second, just that I can start hanging around already. We're going to discuss them in detail because they're absolutely key and crucial in our next session. Hardcore restrictions, loss of exemption for the entire agreement, negative presumption, list of Article 4. Then we go to the excluded restrictions. The legal treatment of these restrictions is different. You lose if you don't comply with what is in Article 5. This time we're talking about Article 5 of your regulation. You lose the benefit of the exemption for that particular restriction. There are no consequences for the application of the block exemption to the rest of the agreement. So if you make a mistake in the Article 5 area, mistakes between quotation marks, you are not losing the block exemption, you just can benefit from the block exemption for that particular Article 5 restriction. And in a second, we'll see what kind of restrictions are on the Article 5 list. Second important consequence, there are no negative presumptions attracted by the application of Article 5, having an exclusive restriction, no negative presumptions in the context of your individual assessment. In other words, you are not facing an uphill evidentiary battle. You can openly see to what extent, without problems, you are potentially meeting the Article 1013 conditions. What are the Article 5 exclude restrictions? Well, Article 5 deals with non-compete obligations, deals with non-compete obligations after the termination of your vertical agreement, and deals with boycotts in certain selective distribution contexts. Again, we're going to look at the details here because there are, of course, nuances. Not every non-compete obligation is non-block exempted, only certain are falling outside the block exemption. But again, the purpose of this slide is to plant in your brains already that these are the topics we're going to be discussing when we deal in detail with Article 5, the article addressing the excluded restrictions. Voila. With that, we have, I think, accomplished already a lot. We know when we land in the scope of application, you understand the concept of hardcore restrictions and its legal implications. You understand the concept of exclude restrictions and its legal implications, and you have a first flavor of what is on the Article 4 list or what is on the Article 5 list. And again, bear with us, we're going to bore you to death with the details behind Article 4 and Article 5 in the next sessions. We have been speaking a lot, Luc. I think it's time to switch gears here and to make you help us resolve certain issues. And the way we do that is typically, and normally when we meet physically, it's much more pleasant, to be honest. We make small groups and we make a big mess of the room at the VBO by rearranging tables, but unfortunately that is not possible. So we'll do it this way. The workshops. And the workshops are based on real life situations which are anonymized, but are very close to things which we have encountered in practice.
And to take part in the workshops, you have to get the regulation out so that you can form your opinion what we're going to ask you.
I hope you have regulation. We will also have workshops next time. So if you don't have the regulation at hand, please bring it with you next time. I hope Valerie, it's somewhere on the website.
Those modern people all have two screens, so you put the regulation on your one screen while we can still see you on the other screen.
Here's workshop 1. We used to be talking about President Trump, but we've adjusted that. The new president in the US.
It was Obama before.
It was Obama before. Maybe not surprisingly, Mr. Biden follows in the footsteps of President Obama. I don't think that Trump was thinking in the same way, and further liberalizes the political and business relations with Cuba. The Cuban business world is enthusiastic and jumps on the new opportunities, including conquering the European markets. Crystal, as the name of a company, is a Cuban producer of household appliances and is among the first to start selling in the EEA, European Economic Area, market. It identifies a number of companies that are prepared to invest in the brand of Crystal. Crystal, in turn, is prepared to grant these distributors exclusive rights for certain parts of the EEA. In return, Crystal wishes these distributors to accept a non-compete obligation of 10 years. Following some exchanges with a former Brussels School of Competition student, the in-house lawyers of Crystal advised their business colleagues to reduce the term of the non-compete obligation from 10 years to 5 years. They understand that it would be beneficial to operate within the parameters of Regulation 330, and that Article 5 of that regulation exempts non-compete obligations having a fixed term of 5 years. Crystal's business team is not particularly pleased with the advice. The 10 years were part of the strategic plan of the deal. They contact you and ask whether it is really necessary to accept a reduction to 5 years in line with Article 5 of the regulation, and whether the risk and exposure would really be great if they were to stick to the 10 years. We give you 1 minute to reflect. The question is, what do you think? You're the Brussels School Competition student that gets this question, and it's up to you to offer strategic and, of course, legal advice on that issue. 1 minute to reflect, Nick?
Yes. Now, think about what we have been telling you until now about Article 5 and about safe harbors in general and about different issues, and then maybe have a look at Article 5 itself and then say, okay, what is your advice? Do you follow the advice of the former Brussels School of Competition student and say, reduce the 10 years to 5 years? Or do you say, no need for that? There are good reasons and there's no need for legal reasons to limit.
And maybe one small piece of advice. You've heard from Luc that there's a lot of thinking behind the rules of the block exemption. Why are certain rules there? But that's where Luc steps in, and then I step in as a lawyer, and I approach this deal very mechanically. That's also, I think, when you get these questions, what you should do. Very mechanically see in legal terms what is there and follow a sort of thinking matrix to arrive at your conclusion. I see no smiling faces. That is troublesome.
So, is there already someone who thinks, I think I have a good advice? I know what I would.
Well, first point to consider would be if we are talking about an appreciable effect of the scenario here. So we might want to consider taking a look at the market shares, the parties. In this example, I think it wasn't active on the market beforehand. So it's quite possible that we will be within the de minimis notice. We do not seem to have a hardcore restriction or by object restriction, as we're talking about a non-compete exclusivity clause here. And so we might even be outside of the vertical block exemption regulation. If we exceed the market shares in the de minimis notice, then obviously we should consider the non-compete under Article 5. And as we've seen, it's just a gray clause, so it means we don't have this all or nothing effect. So even if the specific clause falls outside of the regulation, then still the rest of the agreement may profit from it. And I think what happens to the rest of the agreement will be determined by national law. So we should be careful to draft the agreement accordingly, so that the rest of the agreement will remain in place, at least.
I see that I'm looking at the screen here. I see also the face of Till Fisher. Till, are you in agreement with what Christian is saying? I haven't seen you nodding yes. So would you follow our aggressive advice of Christian here?
I think there were some good advices in it. I mean, he was right to, in first point, say, would it even be covered under the governing law here, considering market shares? I mean, we don't know anything about that. So that would definitely be something to determine first, if we should give more specific advice. And apart from that, I agree.
On the point where you say question mark, do we really have a question mark if you look at the question? In terms of the market shares and what have you, do we have a question?
Beg my pardon?
Well, you were saying that you would have to check what the market share is to know how to proceed, but is that an open issue if you look at the case?
I mean, it could be. I mean, the question for me, or what they are asking me, is if there is no chance to extend this non-compete agreement to 10 years, if I got this right. So if we would file under the de minimis notice, then in my opinion, it will be possible, contrary to Article 5.
And would there be a problem for Crystal to fall under the de minimis notice?
Pardon me?
Would there be a problem for Crystal, the Cuban producer, to fall under the de minimis notice? If you look at it.
No, I mean, that will be beneficial for them.
Yeah.
I mean, they don't have any market shares yet. They're just thinking about entering the market. But if we're talking about the distributors, it may be a different scenario, right?
That is, I think,
depending on the market that we consider here.
For Crystal, it's a new entrant, so there will no.
Yeah, I mean, of course, you would have to count their distributors towards Crystal itself. I mean, that was obvious for me that we are not talking about Crystal, but their distributors on the EAA.
Yeah. Anybody else who has a view or wants to add something, or are we close to getting a result?
I do maybe have one comment. Hey, it was just that you have the exception, right? That normally it should not be more than 5 years, but when it's inside of a building that is owned by the supplier, then you can extend the non-compete obligation. So yeah, then you can go up to 10 years, as long as it does not exceed the period of the occupancy of the premises.
Certainly right, but I must disappoint you. I think our Cuban friend has really nothing in Europe. They're just new. But I think we have
Alejandra, what did you want to say?
Yes, I have a question. So imagine, of course, household appliances, it's a product that already exists. So my question is, what happens if the product that will be brought by the Cuban producer is a new product? In that case, is the market also zero, or because it's a new product, then it would be 100? I always had that question.
Yeah. That's a good question, because it did indeed come up in the writing of the regulations. What do you do if someone brings on the market a new product which creates a market, basically? And it might also be, it creates a market not even by being totally new, but by replacing an existing product, by being so superior that the existing products do not really compete anymore with the new product. So let's say like CDs. CDs were replaced, at least when I was young, the idea was that CDs would totally replace vinyl. It has turned out a bit different maybe, but at the time it was so novel and was said to be you could stretch it and it wouldn't make any difference. While all the vinyl records, there was always this tick when you were turning it. You had to handle it very carefully. So this was going to be the new thing. And indeed, there is some text. I'm not even sure it's in the guidelines or in the regulation, but the moment that you have in the guidelines, the moment that you have a new product, then the first year it is presumed to be zero, also if you are already on the market, because anyhow, you have to calculate the market share for the previous year. So if you enter in 1 year, in year one, then in principle you are the monopolist of the new product, but you can benefit from the block assumption because in year one, your market share is zero because you look at the previous year when you were not yet on the market. It's only the year later that you go above 30%, and then you in principle start to fall outside. But then in article, I don't know, 7 or 8, there is a rule which says the moment that you go over the market share threshold, you have an additional 1 year, sometimes 2 years, depending on how much you go over it, in which you are still covered by the block assumption. So if you are now still the monopolist, you would at least have also the second year that you're covered by the block assumption. So only the third year you start to fall outside the block assumption, legally and technically.
Yeah. Let me grab together what you said. I think we're very close to the right answer. The non-compete obligation we're talking about is clearly not an object restriction, it's an effects restriction. In other words, we are entitled to make a de minimis line of argumentation. We know for sure that Crystal is a new entrant, as Luc was just outlining, and in that context, normally speaking, they would have a zero market share. And then the question, of course, is would they rise to 15% or not? But at least at the start, they are at a zero position, well below the 15%. In those circumstances, the non-compete obligation could benefit from the de minimis treatment on the condition that also the distributors which are designated by Crystal would indeed remain below the de minimis level. Technically speaking, as Luc pointed out, and that is certainly right, even if you exceed the 15%, you could still make a de minimis line of argumentation. I can tell you in my practice, I never take the risk. Then I start assuming that I will need an exemption, so I don't take the risk. So the real question here would be, what is the profile of your distributor? Would that distributor indeed have a market share in excess of 15%? If the answer, because for instance, Crystal will be working with one of the very big chains that accounts for 20% of the household appliances market, for instance. But if that is not the case, then indeed an extension from 5 to 10 years would be a workable scenario for Crystal in this context. And again, if you look in some of the old competition policy reports, I think there was a reference to, I think it was either Suzuki or Honda, that indeed had made use of the de minimis notice to indeed extend its non-compete obligation from 5 years to 10 years. And they applied, of course, given cumulative effects, a 5% limitation of the diminished notice rather than the 15% limitation. So the scenario would be, absent a very, very powerful distributor with a market share in excess of the de minimis limit of 15%, the answer in this case would be probably Crystal can go from 5 to 10 years, if that is indeed helpful to approach the market. I don't know, Luc, whether you would like to add some of the policy considerations.
Yes, I mean, first, Alejandra, indeed, it's Article 7 of the regulation about this 1x a year and about the rules how to calculate the market share. So it's Article 7 and in particular 7D and E, I think, which are most relevant for you.
Thank you.
So what is the concern about the non-compete? And as I already said, I mean, the first thing that a non-compete, of course, can do is it may foreclose other suppliers having access to the market. But you need coverage for that. I mean, if Crystal has 1 or 2 distributors and has a market share of 5% or 10%, then there must be many other distributors available to competing producers of the same appliances, and therefore there's no possibility to foreclose other suppliers. And that's why it's logical that you have the de minimis and the block assumption. The duration is relevant because you can also understand that the potential to foreclose rivals will increase normally if the duration of the non-compete is longer. If you have a non-compete of 10 or 20 years, it is more difficult for others to enter the market than if the non-competes are only lasting 1 or 2 years, meaning that the contracts and the distributors come on the market on a regular basis, giving potential access to competing manufacturers to have access to these distributors by convincing them to take their brand and to not accept the non-compete. The 5 years is you can argue, as all those kind of limits are, is arbitrary. But the main reason for us to introduce a time limitation for the coverage by the block assumption was that on the one hand, when we talked to different sectors, at the time, it was in particular the beer and the petrol sector that came very strongly to us and saying we need long-term non-competes because we invest in the pubs and in the petrol retailers, and therefore we need long-term non-competes. And when we asked them what investments they were doing and what that could justify in terms of duration, they were not very convincing in arguing that they needed a long duration non-compete. I mean, the brewers were saying we are providing glasses and furnitures and whatever, but if you then ask them how often do you have to replace all that, it was always in 1 or 2 or 3 years, but certainly within 5 years. So there was no need to tie pubs for longer periods. And if they were saying, yeah, but we also give loans, then it was also clear that the loans could be easily transferred to a next brewer. So it was not that there was much specifics in the situations that required a long-term non-compete. And the same for the petrol stations. All the investments in the outfittings and etc. that were specific were normally depreciated quite quickly. And the longer-term investments, like the petrol tank in the ground, they could easily be used for any brand. So they didn't add up to a good reason to have long-term duration non-competes. At the same time, so there was a lesser likelihood of the efficiency. So at the same time, the likelihood of the foreclosure was increasing with the long duration, which made us think it would be good to have a time limitation, to have a certain fluidity in the market, in particular also because of the potential for cumulative effect problems. I mean, one thing that you see in vertical relationships and vertical restrictions is that very often in a particular sector, the same restrictions are applied by many. So it is not just one brewer who has non-compete with the pubs, but all brewers tend to use it. It's not just one petrol company who requires a non-compete on the petrol retailers, but they all do. So you have a cumulative effect problem. And of course, with a market share of 30%, that means that if there are 3 or 4 suppliers with 20-30% market share, you easily foreclose a very large size of the market. If then, in addition, the non-competes are of a very long duration, it becomes virtually impossible for others to enter. If you have a time limitation, then at least on a regular basis, at least 20% of the contracts comes onto the market, and others could also compete for those particular distributors. And that brings me a bit to the kind of balancing that you have more in general. So here you have the non-compete. So you have this foreclosure element, that's the main issue. And then there's also softening of competition and facilitation of collusion. The softening of competition could evolve from the fact that if you have only one brand in the shop, that means that in the shop you have no longer inter-brand competition. It means that it becomes more difficult for consumers to compare products. It is more effort. You have to do more cost. You have to go to 2 shops to compare. And that means that it reduces the incentive to compete and might increase the prices somewhat. But we all understand this can only be a risk if it is at least a good size of the market that is being covered by these types of agreements. And therefore, again, there is a reason to have the market share threshold, etc. The same for the of the collusion. I mean, how could a non-compete help firms to collude? In the sense that if you have non-compete agreements, it may have 2 types of effects. One is every time a contract comes onto the market, every time a contract ends and a distributor becomes free to give access to new suppliers, there's very strong competition for the distributor, which may lead to extra competition. But more likely is when you have only a limited number of suppliers, is that they all start and tend to become very much aware that if I try to take Frank's distributors, who are currently loyal to Frank, and I bid very heavily for them to switch to my system, Frank will do the same with me. So it's much better if we both do not compete too strong for the access to the distributors of our rival brands. And of course, that means that you have a kind of collusive or softening of competition effect in the market. However, the non-competes may also be very pro-competitive. And the first reason, of course, is that it may help the suppliers to invest and help the distributors to invest in selling that type of good, and that in a way that it does not at the same time benefit the rival brands, the rival suppliers. I mean, if I am a manufacturer, if I am a brewer and I want to make the pub more attractive to sell more beer, then the downside is that this more attractiveness of the pub will also increase the sales of the rival brands. So I'm more inclined to make the investments and help the pub to increase its attractiveness if I can assure that I only sell my beer. So the incentive to invest is increased if we have the non-compete. And the same, if I train the personnel as a manufacturer of a retailer to sell a particular type of product, then this investment only makes sense if it is used to sell my brand and not to sell the brands of others. And therefore, the non-compete may lead to a better level of services and a higher quality of distribution services by making the manufacturer more interested in investing in the distribution level. The other potential efficiency for which you want to give a safe harbor is that non-competes can be used to what economists call avoid a hold-up problem. you may have situations where the manufacturer, the supplier, has to do particular investments in order to be able to supply to the buyer. For example, the buyer wants specific components, but for me to supply them, I have to build specific machinery which I can only use to make these components for this particular buyer. Now, of course, the moment that I do the investment, but I don't have a non-compete, then the clever buyer will say, very nice that I can buy now these components from you, but the price, I think it's a bit too high. I think I may want to go to another supplier. And you, of course, as a supplier, think, gee, this is not what I wanted. I've already invested my money in specific machinery, which I can only use to provide components to this particular buyer. And now he's threatening to walk away or to buy mainly elsewhere, making my investment useless. In order to, so what I will do is I will say, I will not invest in the first place, unless I know that you are going to buy for the next so many years, at least so much. Now, if I want you to buy at least so much, you may say, yeah, but wait a minute, I'm not sure how much I need. And then what we do is, okay, let's shift risk a bit between us. We agree that you buy only from me. In that sense, I know you will not play the game of switching away to another supplier. You make it profitable for me to invest in machinery which I need to only supply to you. And at the same time, if you need less because demand is falling, because there's an economic downturn, you don't have to buy too much. And that's where, again, where you see that the non-compete may play a very useful efficiency enhancing role to invest and make business happen in the end for the good of the consumer. But of course, for that, the investment that I make as supplier must be specific for you as a customer. It cannot be something general like, oh, I'm increasing capacity and therefore I want to tie you for the next 5 years. Because if I increase capacity in general, I can also use it to sell to others. And the last one is non-competes may be necessary to address capital market imperfections. That I always like to explain with the example of the brewer and the pub, because it's so easy. The bank may want to give loans to a pub, but it has doubts because pub world, risky business, difficult to judge how good pubs are, difficult to judge whether the pub tenant, the one who exploits the pub, is able to not drink too much himself or herself. Therefore, banks may be a bit reluctant to give a loan. The brewer, on the other hand, may have much better knowledge about the quality of the pub and the pub tenant. So therefore, it may be easier for the brewer to give a loan than for the bank to give a loan. On top of that, the brewer may have extra securities because he also sells the beer. And on top of that, between the brewer and the pub tenant, the one who exploits the pub, who operates the pub, there may also be a possibility to shift a bit the risk in a way that is advantageous to both of them. The moment that the brewer gives a loan at a low interest rate, he is lowering the fixed cost of the pub owner. Which is good for the pub owner because it makes it easier to have the pub in good and bad days. But at the same time, this is only possible because the brewer is able to say, but then you have to pay a higher price for the beer. That in itself is a disadvantage for the pub owner, but it is not so much a disadvantage in bad times, and it's a more disadvantage in good times. But in good times, he's earning more anyhow. So what you see is they shift cost from short-term to longer term, to fixed to more variable. The price of the beer goes up, the interest rate of the loan goes down. This is okay for the brewer because he's big enough. This is a better for the puffer because he likes to have a more stable income in a market where demand goes up and down. And that, of course, is mainly possible if then at the same time the pub is not able to switch most of its demand of the beer to somewhere else. Because otherwise what he will do is, in times that demand is high, the pub goes very well, he will start selling other beers. And in times that it goes low, he will still wants to keep the low interest rate from the brewer. And therefore you see vertical restraints like non-competes can be used to solve problems and to create efficiencies. That is true in general. The negative effects are linked to the market shares and to the duration. And therefore there is a cap in 30% and a cap in 5 years in the regulation, which has an economic background. It may look as a bit arbitrary, a bit artificial, but there is thinking behind it, which makes it logical if you look at the pros and cons.
Which brings us to workshop number 2.
Excuse me for interrupting you here in the middle. If you could for a second stay with this first example, and if you could just slightly modify the case by the fact that, for example, Crystal, within the first year of entering the market, by the end of the year, would already achieve between 30 and 50% of market share. What would we advise them regarding the duration of the non-compete?
Yeah, so I mean, if it goes from 30 to, if it goes so quickly and it has a market share of between 30 and 50%, then look at Article 7 E, I think it is, then it is covered by the block exemption still for the next 2 years, because year 1 and year 2 will be covered. But then in year 3, you have the question, you're outside the block exemption, what do you do? The market share is maybe still between 30 and 50%, maybe now even higher. A 10-year non-compete leads to a potential foreclosure issue. At that time, you are not able to limit your duration to 5 years and thereby fall within the block exemption. So there is no possibility, like Frank would love to do, like tickling a bit with the conditions in the contract and fall back into the block exemption. You're outside anyhow, your market share is too high. Then the only thing you can do, and which I also think you should do, is to limit the non-compete to the minimum necessary in order to achieve the efficiencies that you are creating with the non-compete. So if you have good reasons to have a non-compete, like the ones that I just explained, there are investments that you do which only make sense, then you may want to, and you can also explain why you need 10 years for that, then continue with your 10-year non-compete. But if you don't have good arguments to have a non-compete in the first place, or to have it of that duration, then I would argue limit it. The only thing that I would still add is, I would also make an analysis of what are the alternatives for the rivals. So what is the potential to foreclose? I mean, if the possibilities to sell a particular product are very large, so there is not one particular distribution format to which also the rivals have to turn to, you may still not see a problem. I mean, you see many products which are sold in a non-compete type environment. Cars are sold in most countries by dealers who only sell one brand. And those contracts are very long. But that is not a problem because those dealers' investments will anyhow be big for any brand. There are other types of products which are similar, and therefore the long-term duration and the non-compete may not be an issue. There are other products which can be easily sold in many types of outlets. Let's say if you're selling candy can be sold in supermarkets, in tobacconists' shops, in railway stations, in I don't know what else. There are many types of shops where they can be found. If you now have your you can be sold in a particular range of shops where you have a long-term non-compete. But there are many other access points for rivals, including online. Then there may not be a foreclosure issue in the first place. But in general, I would say with a market share of 50%, I would look for, do I have good reasons to have the non-compete, and do I have good reasons of the non-compete of that duration? If not, I would scale it back.
Yeah.
Just one question. In the example the colleague has just given, I think the market share was about 50%. Wouldn't that be an area where we might have to discuss a dominant position on the market, which would make it even harder to actually use an exclusivity clause, a non-compete clause?
Yes and no. I mean, if the Commission would apply the priority guidelines which I wrote some years ago, it should not make it more difficult, in the sense that for the non-compete of single branding and rebates and exclusivity rebates, the same effects-based approach is put forward as you find in the political guidelines for non-dominant firms. The only difference is that, of course, the higher the market share, the bigger the likelihood that if you apply non-compete to all your sales, that there may be a foreclosure effect. So the effects analysis may logically more quickly find effects, but the analysis itself is the same. If you look at the case law, I must say, in Intel, the court has made this switch and said, also for dominant firms, at least in loyalty rebates, and I would presume the same applies to contractual non-competes, there is an effects analysis. The only difference that they've made a small in-between step where they say there is a presumption that it is anti-competitive, but the moment that the company comes forward with some arguments about either a non-effect or efficiencies, the authority should again be responsible for being the first to show the negative effects. So in principle, it looks very much the same.
Now, Till, if I may jump on your example, you could also approach it more from a lawyer's perspective. And again, let me add that complement here. The first point, and I agree with the point made by Christian, of course, if we have 50%, we have this presumption of dominance and what have you. So you really want to make sure you're outside dominance, because I think there you might be taking a risk. Let's take, for assumption's sake, that we are anywhere between 30 and 45%, whatever, and that we're outside dominance. What I would do is I would look in the eyes of my commercial colleagues and say, how important is this for you to maintain the 10 years? And if ever challenged, what kind of storyline can we advance? Look would say absence of foreclosure, limited foreclosure, or potential efficiencies related to the fact that we have this 10-year instead of 5-year non-compete clause. I would like to hear their story. Why do they need this? Is it important for them to take
5 or 10 is not even the relevant issue, because you're outside the block assumption.
Yeah, but the question there is, how much risk are we prepared to take there? And how important is this? Because outside the dominance area, name me an enforcement case where a fine has been imposed for a 10-year non-compete clause of a party having a 39% market share. I don't know any. Maybe Luc knows, but I don't know any. So what is the risk that I run is that my counterparty would run to court for some reason. And then again, we would have to analyze it. To what extent can I then put forward a 113 type of story before the court, and is it credible? 2, I would look at the jurisdiction where the case would be brought. In Belgium, for instance, Supreme Court case law, the judge has the right to mitigate. And typically for non-compete clauses, the right to mitigate. So he could say, 10 years is a bit long, I can bring it back to 7 years. And then the assessment, of course, you have to make is if you've been holding your distributor for longer than where your judge lands upon mitigation, do I run a financial risk of having to compensate my distributor for the fact that he was not able to handle other brands? And of course, it's a bit of a different dialogue to the one which Luc was putting forward, but that from a purely legal perspective is strategically also taking into account the reaction of the judge, the likelihood that indeed the counterparty would want to raise an issue about it, would try maybe to claim damages on account of the protracted or too long nature of the non-compete clause. That kind of legal debate I certainly would be having with my client to understand better where is a sensible risk to take, we're prepared to take a risk, There is a risk element in this anyway. Only the block exemption or the real de minimis scenario gives me the degree of legal certainty that basically allows me to tell my commercial colleagues, sleep on both your ears. But that's the balancing act which I would be engaging as a lawyer from a purely legal perspective.
And I can already tell you in the third session, I will give some data about enforcement. But one thing that comes out indeed is that fines are mainly levied on cases including hardcore restrictions. Cases which are purely about effects-based restrictions are normally not fined. So in that sense, I fully support what Frank said. The risk is in that sense is limited, but if you don't want to get maybe your parties, because that is the kind of practical thing, competition law is sometimes used by parties to fight contractual disputes. So you would expect that the rival manufacturer who is foreclosed by the non-compete goes to court and says, my market access is foreclosed. More often what you find is that one of the parties goes to court and says, I want to have more freedom to sell competing brands and my possibilities have been restrained and this has given me a commercial disadvantage and I want to be reimbursed for that. That type of litigation, of course, is not really competition driven because it is not really that the other side of the relationship is pleading here for more competition and access to the market. Now, what is really pleading for is for a redistribution of the profits that were made in the past.
I mean,
sorry, go ahead.
If I may, that was exactly, as Frank mentioned, the direction that my question was pointing to. From a consultant's perspective, as long as we don't know in which height will be the market share after the entry of the new company, will we, if they ask us for advice and say, okay, we for this and this reason want to have like a 10-year non-compete agreement, will we just say, okay, go ahead? And in the case that the market share will rise too quickly, then from an ex-ante perspective, adapt that or lower it or kick it out after 2 years, or we will like in the first place advise them and say, okay, is it really utterly necessary? And if not, then we would from the beginning already try to reduce that or even kick it out from the beginning.
Yeah, it's a bit of a risk assessment which you're making, in fact. It's a balancing act.
But I would say limited to what you can defend in court.
All right.
Building quickly on the example Luc gave, it's interesting. It's now over, but there has been a petrol station war in this country where exactly what's happening, what Luc was explaining, whereby one petrol brand was in fact funding litigation entered into by the petrol station owner, the local owner, in order to fight his contract on the basis of competition law to say that he was bound for too long a duration in order to free up the relationship so that the other petrol brand could come in on that very important spot somewhere on a highway or what have you. And that's a typical case where indeed for private relationship purposes, purely private contractual purposes, competition law is being used. But that's fair. That's competition law is part of the overall legislation applicable to contracts.
Another idea might be just to conclude a renegotiation clause so that after 5 years, the parties sit together and will renegotiate a new non-compete clause. And I think maybe even under the new draft block exemption regulation, I think it might be a bit more flexible with regard to an automatic renewal, but I think it still remains to be seen how that story ends.
You're right. The tacit renewal possibility has been put in. I'm not in total agreement with the text as it stands, so I would be surprised if it doesn't get amended. Because
but that we'll deal with next session.
That's something we deal with next session. But you're right, Christian. Another alternative is one playing with the definition of non-compete in the block exemption. But again, let's reserve that for next time because there we really can play interesting games. Luc doesn't like the word games, but as lawyers, we're used to work with definitions and see how we can put them to work for us. Workshop 2, if you are in agreement. The Belgian distributor of Crystal is doing a smashing job. Admittedly, in order to get that distributor on board, Crystal had to reduce the non-compete to 5 years, but that is a price which Crystal was more than willing to pay. The Belgian distributor is really top and has brought Crystal in less than 3 years to the fourth position in the Belgian market with a market share of 17%. To its surprise, Crystal learns that the Belgian distributor is not sticking to its non-compete obligation. On the wave of the success with the Crystal brand, it has been approached by other brands, and such other brands can now be found in the stores of the Belgian distributor, and that was not the deal. Crystal threatens to sue the Belgian distributor for breach of contract. After all, Crystal is quite happy that it has adjusted the term of the non-compete obligation so that the enforceability of that provision cannot be a point of debate. Crystal will simply invoke the block exemption. Now, the lawyers of the Belgian distributor have anticipated on that line of reasoning and write back that Crystal should not be so naive as to think that it can use the block exemption. The agreement, which by the way is printed on Crystal-headed notepaper, contains a clause requiring the distributor to respect certain minimum prices. That is vertical price fixing, which is prohibited by the block exemption in its Article 4A. The lawyers are clear that this is the end of the story. The block exemption is out and the non-compete provision is simply not enforceable. The in-house legal team of Crystal checks the contract and finds indeed a two-line provision imposing certain minimum prices, in particular not to price below 140% of the wholesale price, so at least to take a 40% minimum margin. This clause is perfectly valid under Cuban competition law, and after checking with the business team, it is clear that Crystal has never in practice implemented or even referred to the clause in Belgium. The business reality is that this clause is, at least in practical terms, non-existent. Crystal is therefore not impressed by the counter-argument of the lawyers of the Belgian distributor, but before suing the Belgian distributor, wishes to double-check the position with you. And you, after all, are a prominent student of the Brussels School of Competition. You should be able to advise Crystal in this respect. So the question here, obvious, is what, in that sort of scenario, what is your advice? We'll give you a minute again to reflect and digest the facts.
And then whoever wants to speak, please do so. And it's also good if the others could also open up their cameras.
Shall we get the discussion going? Ola, would you mind if we come in your direction to see what you think about this, this particular case? You do mind? Not yet ready.
Is there someone else? Beatrice, Kyriakos, or Charlotte, or Daniel, or one of the people who have not their camera on, Judith or Aya? Who dares to give an advice and say, okay, I mean, this is...
I have the feeling that Charlotte is ready.
Yeah.
Charlotte, take the mic, and you know we're amongst friends, so we can. We're amongst friends.
Right. Well, I mean, it doesn't really matter. Well, I think we have a price fixing agreement in there, and from my perspective, it doesn't really matter whether that agreement was lived or that clause was lived in Belgium or not. I think it's sufficient that it's already in there in this agreement. So it's basically the opposite of what we discussed before, that it does not have to be written. In this case, it is written, but it's maybe not lived. We don't know. But I think this is also problematic. And now this is a violation of Article 4A. And so I'm actually thinking, I'm not sure at this stage whether I'm reading the block exemption parallel. I'm not really sure whether in this, and well, let me put it that way. I think this means that the whole agreement is not covered by the block exemption, and we cannot enforce the non-compete clause either. So the advice would be to leave it but to just accept the violation of the non-compete clause, because otherwise we might have a different problem if well, we might have it anyway, but we might yeah get to that problem faster than we might think of with regard to the price fixing clause.
Yeah, I think that's already extremely helpful, Charlotte, what you're saying, and I think we're 75% on the way. No, perfect. Thanks for the contribution. It's the last tiny bit of what Charlotte was saying where I'm slightly hesitant, but I think the setup which she launched was really perfect.
Is there someone else who has something to add, or maybe who disagrees, who thinks one should be more bolder and say, listen, I mean, never used, never implemented, therefore no real agreement, therefore no problem, sue the distributor.
Yeah.
I mean, I would probably, as a lawyer of Crystal, argue that it might not be an by object infringement with regard to the fact that it actually does not intend to restrict competition. I mean, if we then come to the point to ask ourselves, is it a by affect agreement? We will probably say no, because I mean, this clause is not enforced. Nobody sticks to that clause. So it is by no means an by affect infringement. And the question is now, is there any chance to get around that point that we say, okay, actually restriction of free price setting, or the conclusion that there has to be a minimum price under which a product must not be sold. Can this case not be constituted by object infringement because it is 100% legal under Cuban competition law, and it was just simply maybe forgotten in the contract that was not adopted to Belgian competition law or adapted? I mean, that would just be what I would argue if I would be a lawyer for Crystal and trying to defend that here.
Yeah. Thank you, Till.
I would add that I would try to argue the same and saying, well, it may be written in the contract, but it was never intended, as it says in the contract, provided that would be very hard to prove.
Let me already take that first step, because I think there is a bit of contradiction between what Till and Jan are saying, and I think what Charlotte has been saying. Let's first look at, why do we have two elements? We have the non-compete clause on the one hand. We have got a vertical price fixing provision which has been put in print but never applied. On the other hand, let's first start with the latter, the vertical price fixing clause. The fact that it has not been implemented, what does that do to the application of Article 4, the hardcore list, or the fact that it was never intended to be implemented? Does that alter the legal position under Article 4A? I think that was my first question. What do you think?
Probably not. At least Article 4 doesn't say anything about that. So we assume that it actually doesn't make a change.
Yeah. But then I think go ahead, Alejandra.
I think it should be taken into account, because if you say that a vertical agreement is not only what it's written, but it's also what happens in real life, I think at least if it can be evidence that indeed it was not implemented or even intended to be implemented, and the distributor has not been following them, I would argue for sure that the agreement is still in place, and provided that the clause is excluded, it should be respected.
I think we have to draw a distinction between the block exemption regulation here and the discussion of an individual exemption. I think under the block exemption regulation, it would be the end of legal certainty if we were able to start discussing, well, it was actually never meant to be implemented. And then you would actually have to perform a detailed analysis of the effects of each clause. Whilst the block exemption regulation is actually all about the, as you have pointed out, the tick the box approach, where you're supposed to take a look at the agreement and easily determine whether it can be applied or not.
Yeah. And I think let's try to round off on that first element, building on what Tila said and Christian has said on the vertical price fixing side. Remember that Luc said, well, we could have an intention debate, but we don't want that. Exactly for the reason which was just mentioned. So the fact that the parties intended maybe something else is not going to be resolving anything, because in the object box area, we don't want to launch a debate about intention, yes or no. Same thing here. I very much admire Alejandra's creativity, and as a lawyer, maybe I would want to say, well, in practice, the parties have agreed on something else, so the contract is no longer a real reflection of the agreement. Let me be honest, Alejandra, at least before the judges, I've been pleading it will not fly. They will say it's there. It's an object restriction, Article 4A. I don't have to look at the effects. I don't have to look at the intention. It's there, my dear friend. You cannot look besides that. And I'm afraid that that is the legal position. That's inherent in the tick the box approach of the block exemption. The consequence is that, as I think Charlotte was saying correctly, that means the end of the application of the block exemption to the whole agreement, which means, and up to there, I was in agreement with Charlotte, that we will not be able to rely on the block exemption to say, hey, it's 5 years, beautiful. Article 5 permits fixed term of 5 years, therefore I'm covered by the block exemption. That is something I will no longer be able to do because the block exemption is no longer available to me. But that is not the end of the story. As we discussed at the beginning of the session, you always still have the right to engage in self-assessment. And there I am not so pessimistic, I must say. The 5 years, 17% market share. The 5 years is compatible with what we find in block exemption. Apparently the Commission found it safe enough to create a safe harbor for a 5-year non-compete obligation for somebody having a market share even up to 30%. Well, I would want maybe to take my chances to defend in court that this clause is indeed valid and enforceable in accordance with the self-assessment of 1013. The only problem we have, of course, is that we will not know until the judgment of the judge lands on our desk. There's no way we know whether our self-assessment will fly or not fly. But in terms of advice on the specific point which was raised, have the lawyers of the distributor a point by raising this vertical price fixing issue? The answer is they really have a point. The block exemption is really out, and please do not believe that you can rely on a block exemption. This may sound, and I know that Luc sometimes has reservations, artificial. This is a case which comes from my practice. That's what I encountered in practice. We had to plead a case in court where indeed a clause was there, and the judge basically said, sorry, my friends, don't start reasoning in block exemption terms. The clause is there, and I cannot deny that. But then, of course, self-assessment is still a possibility, and there I'm not so pessimistic, to be honest.
Yes.
If I might jump in here again, I was just thinking about what happens with the price fixing agreement. I mean, we would still face the risk that we might get fined for that.
Yes, Charlotte, that's again, when I give legal advice, take you to my kitchen, when I get a client who really has a clause like that, and the story about we have never applied it, I can tell you, in 9 cases out of 10, they always tell me that, Frank, never applied this. Oh, I'm so surprised to read it here. But when I see that, I just don't take the risk because I know what is going to happen. There's going to be blackmail from the other side. They're going to start threatening with a complaint with the competition authority and say, okay, if indeed that's the way you're going to play it, we will lodge a complaint. And if you have been looking at what has been coming out in the past month, almost every day, there has been an RPM decision from one or the other national competition authority with a fine attached to it. So that would be a very credible form of blackmail or threats in reality. So in all honesty, I would not certainly launch here a case. I would not take as Crystal the risk of having a complaint the next day on my desk where I have to justify my behavior before the National Competition Authority.
Yes. And wait.
Sorry, I just wanted to ask a question. If there were any like retaliation mechanisms or any things like that, like enforcing the use of the minimum prices? Is there like a difference in the analysis?
Yes, I think so. I mean, Frank will say, I mean, firstly, I think we all agree legally for the coverage of the block assumption, it makes no distinction whether it was implemented or not, whether there were threats or not. The fact that there's an RPM clause makes the agreement fall outside the block assumption. The real question is then, what happens next? What happens next in terms of if it would land up in a national court who would be asked to look at the agreement individually, and what would happen if it would land on the desk of an authority because someone was complaining about it. And there it makes, I think, a big difference whether one can argue truly this was something without any effect, or whether parties can, or those who bring it on the desk of the court or whatever else, can show, no, this was really implemented, or there were threats or whatever. That makes a big distinction. So let me give the example. If one could find and argue that in this example, there is the 140% minimum that you have to apply for the in terms of the wholesale price. But everyone knows that in Belgium, because Belgian labor is so expensive, that the distribution margin is always 80% and more. And so prices are never below 180. And that sounds a bit like darts, never below 180. And therefore, the 140 is really not effective and plays no role in any commercial circumstance. Then I think you've got good arguments to convince the court to say this should not affect the agreement and this should not affect the non-compete and the 5 years. And also, I would think that there would be no authority who would want to take up such a case and go forward with a prohibition for something which has such eminent lack of effect. I think, however, in practice, and that is, of course, Frank comes with a case from his rich lawyer practice, where there's always this one case where someone has truly forgotten something from a contract which was never implemented. In practice, the typical case of RPM looks different. And there, Beatrice, there your scenario comes much more realistic. What we find in practice is the RPM is implemented by large brands. It's always the kind of companies like Philips and Samsung, etc., who are having the RPM. And what you normally see is a whole play around the RPM. So it's often that the manufacturer indicates or advises a price, and then he also puts some pressure and some monitoring about whether the distributors do implement. And then distributors who see others going below that price start to complain, and they start to complain to the manufacturer that he should do something about this ruining of the market and this disloyal competition by other distributors. And then there's pressure from the manufacturer on the distributor who is lowering the price to increase the price again. And then is also, Beatrice, where there your types of punishment mechanisms, etc., come in. And that is what we normally see as a case. And then, of course, it's very difficult to argue, oh, it was without effect and it was never implemented, etc. But I think, in the next session, we will go deeply into the RPM, and I will go deeply into the pros and cons of RPM. But for the moment, I think this is enough. But it is certainly true that at the first step, you're worse off if there's an RPM clause in your contract, because you lose the benefit of the block assumption, and therefore you end up in this individual assessment. And only if you can show it was really without effect and never implemented, you're also, for a second reason, in a bad predicament, because then it is a real RPM which normally will be pursued, and the court will normally say, therefore, your agreement is null and void because the efficiencies are normally absent, etc. So you have a good chance that the individual assessment leads to a negative decision either by the authority or the court. And that, of course, means that then, if the agreement is null and void, then the other side is now free to sell whatever other brands they want.
Any more questions on this one? The bottom line, of course, we want to throw in your direction is the interplay, the mechanics of having a hardcore restriction with a non-hardcore restriction, and then the interplay of block exemption, individual assessment. And that's the key point in this workshop. We wanted to bring to your attention. We continue with the third workshop. I hope there are not too many German friends on the course, because as always, it is difficult in Germany. Results in Germany compare poorly with the Belgian success. It has become obvious, unfortunately, rather quickly, that the German distributor is not up to par. He faces severe competition from the brilliant German brands, and the distributors of these brands have little difficulty in convincing German consumers that Crystal is not the brand of the future. Crystal is quick on the ball and changes tactics. It approaches one of the German household appliance manufacturers, Gerät AG, and invites it to become its importer for Germany. Gerät has an excellent network of distributors and is happy to take the Crystal brands on board. Crystal realizes that it is ridiculous to request Gerät to accept a non-compete obligation. It will obviously continue to sell its own brands. Crystal is, however, concerned that it may be willing to accept to become the importer for Bucanero, another Cuban household appliance producer that has announced that it will become active in Europe, presumably as a consequence of the success of Crystal in Europe. Gerät has no objection in principle to an obligation not to take Bucanero on board, but it is a bit lost. The relationship with Crystal is obviously vertical, but is it covered by the block exemption? Should Gerät worry? Should Crystal worry? What do you think? How would you advise? Are the facts sufficiently clear?
You can reread the text, maybe.
Yeah, I think you have the slides, I hope.
Do you have the slides at home? The slides were sent to you, so you should be able to look at them.
Yes, the slides and the regulations.
Yes.
Yeah.
Okay, who goes first? You saw from the brilliant intervention of Charlotte that going first is always good. So don't hesitate.
Maybe if somebody else could pick up.
Maybe some of the people who have put their camera off, maybe you can put your camera on. Hattis or Annabelle.
And again, approach this to begin with very mechanically. And the question is, we have Gerät, we have Crystal. Crystal would like to have a closing agreement with Gerät, that Gerät will never take Bucanero, a competitor of Crystal, on board in this agreement. And the question is, of course, the relationship between Crystal and Gerät is vertical. For the purpose of that agreement, Crystal is supplying to Gerät. And the question then is, this sort of non-compete-like clause on Bucanero, is that something which can be covered by the block exemption? That is the basic question we're asking.
Yes. And is it covered by the block exemption?
Yeah.
If the market share thresholds are, so just assume that market share thresholds are being respected. That's not a problem. They're all below 30%.
Yeah. I'm almost tempted to go back to Yola, but I don't think that she's going to jump in. Yola, are we able to convince you to give your analysis? Not really. I don't know. Julien, are you able to share your thoughts?
I'm not quite sure about this one, to be honest. It was the first reflection that I had. was to see what the market share of of Gerät was in Germany, but I'm not really able to think further than that.
Think about Article 2.4, what we told about agreements between competitors. That's where you should look for it. That's where you should find the answer to Frank's mechanical question.
So we're having here a mixture of three competitors. We have Gerät AG, who's a producer of household appliances, German brands. We have Crystal, Cuban producer, and Bucanero, who is also a producer. And the contract here is between Gerät and Crystal. Beatrice, do you have a thought? I think I saw your hand move. It's always dangerous to move your hand. And now she's pulling back.
Actually, I think that it would the exemption would not apply because the Gerät is actually a competitor of Crystal in the manufacturing layer of the chain.
Yeah, no, I think you're right on track.
Yeah.
So it's an agreement between competitors. You were saying Gerät is also, who's the one buying from Crystal, is also a producer. And then the question, of course, is, and as a real underlying question, can we make use of this dual distribution exception in Article 2.4 in this scenario? Yes or no? That's the question.
Yes. So Beatrice says you cannot make use of the block assumption regulation. Is there someone else who thinks differently? Or thinks, nah, I think it can, and this is still vertical enough to be covered by the block assumption regulation. And the market shares are all below 30%, so.
I don't know, Sonia, do you have a view on that? No view. I know we're causing really trouble on Friday evening, Eric.
Is there someone else who has a...
Because we're well on track, but Beatrice has given an opening. It's like in soccer, the ball is in the air. It's just a matter of heading it in the goal now. Oh, we shall help you. We shall release you. It is a painful Friday afternoon. It's grey outside. The temperature is lousy, 6 degrees at least in Brussels. And maybe it's even raining a little bit. So, Beatrice, you're right on track. Article 2.4 is a right article. We're talking about two competing manufacturers. You remember that Luc did, it was pretty nice, where he did the vertical agreement can be between competitors if you look at the definition. And in Article 2.4, we take out all the vertical agreements between competitors, and we put back in just one type of vertical agreements between competitors, namely dual distribution. And dual distribution means that the competitive relationship appears at the downstream level, but never at the production level. Gerät is producer, Crystal is producer. Article 2.4 says this agreement will not be covered by the block exemption, so we are out. And then the question is, what do we do? What is, and again, that goes back to the very first minutes of our session. Where will you be looking at guidance to see what you can do here?
The horizontal guidelines, I guess.
Brilliant, brilliant. There you have a section dealing with commercialization agreements, which typically envisages this type of setup, and the one we have now with Gerät and Crystal. And there you have a framework of analysis. It will be, again, self-assessment. But at least you get some guidance in the guidelines as to how that assessment needs to be conducted.
Yes, so you can go to the solution slide. Of course, the logic is, I mean, the first thing that you think about when Gerät starts to distribute Crystal's competing products is that what will this mean for price competition between Crystal and Gerät? So what does it mean what does it mean for competition between Crystal and Gerät? And the same, you could ask yourself the question about what is the effect of the exclusion of Bucanero from Crystal, although that is probably less problematic. Well, the first thing that you think about if you want to look at the effects of this agreement is this might limit competition on the market between two brands of appliances which compete for the same consumer demand. And therefore, that's the economic or the policy logic. If that's the problem, then you do not want to cover it by the verticals, because the verticals is not about loss of competition between the parties. Article 2.4 is only covering certain dual distribution exceptions, because there it is, from experience, considered that the loss of competition between the parties is normally not the issue. Here, you have the two manufacturers, so it is clear cut from the text of the regulation, it's outside. And also, if you think in terms of this particular example, then what you want to have an addition of competition on the market, and you don't want that all brands use the same, use only one of them as distribution channel, and thereby basically fix the price for all the appliances on the market.
Let's take a final one, and then almost release. The final workshop for today. The stellar performance of Crystal in the EEA is causing luxury problems. The Crystal products tend to be sold out quickly, and the shipping of additional volumes from Cuba is simply taking too much time. The conclusion is rather straightforward. Crystal needs local European production. It does not have the financial resources to set up its own factory in Europe, and therefore turns to a local producer, the all-producer BV, also known as TAP, and obviously a Dutch company. This company is not active on the same product market, but produces products for related product markets. TAP is willing to take the production of the Crystal appliances on board, but lacks the technical input that is needed to do so. Subject to stringent confidentiality undertakings, Crystal is prepared to provide crucial technical know-how and all the necessary production drawings to TAP. This should enable TAP to engage in quality production of the Crystal brand. Having been alerted to the Dutch trader spirit, Crystal is a bit afraid that TAP may also start selling the Crystal products through its own distribution channels and relationships. That is obviously not the idea. TAP is supposed to produce for Crystal and only for Crystal. All of the production must be supplied back to Crystal. TAP understands the concern and accepts smilingly an exclusive supply back obligation. All of the TAP production will go to Crystal. TAP's lawyers are adamant that the clause in the agreement as drafted will be enforceable. It is covered by the block exemption. The supply relationship is a vertical agreement that falls within the scope of the regulation, and there are also no market share concerns, which in fact is the hypothesis in all our workshops. Both remain well below the 30% limit. Crystal wants to be absolutely sure, because rightfully so, you never know with the Dutch. And I get kicked in a second here.
What is this?
The question is, what do you think? How do you advise?
Well, first off, I think we're talking about an exclusive supply clause here, which is not covered by the non-compete definition under the WIBA. So I think it wouldn't be limited to 5 years in the first place, but we could also discuss the topic we referred to earlier, the subcontracting notice, because here the essential know-how that is required to produce the products in the first place was provided by Crystal, and accordingly we could argue that we're not even within the scope of Article 101, and therefore there would be no limits on the scope of a non-compete or exclusivity clause here.
Let's take for a second maybe the block exemption first, just as a matter of checking. Could the block exemption apply in this particular context? And again, let me refer here to Article 2, paragraph 3 of the regulation to give you a bit of guidance.
I mean, the Dutch TAP lawyer is arguing that the block exemption covers, and therefore the agreement will anyhow be enforceable. So is the Dutch lawyer that Frank is so suspicious of. Is the Dutch lawyer right or wrong?
Yeah.
So you refer to the question whether we're talking about IPR as a main purpose of the agreement here. Well, I would argue it's not, because actually what the parties want, what the contract is all about, is the actual supply of the products.
I agree.
And not an independent licensing agreement. I think the economic rationale is actually the supply relationships. So I would argue that the block exemption regulation does apply here, and we do have under the regulation some leeway with regard to the duration of the non-compete clause, but we could even argue that we are talking about subcontracting case here.
Technically, let's stick to the block exemption situation
For
first.
the moment. But does everyone agree with Christian? So Christian says block exemption applies, and in addition, it might also fall outside 111 because of subcontracting and the supply of the indispensable IPRs. Does everyone agree on the first thing? Block exemption applies because the main the main part of the agreement is the production and supply of the goods, and therefore the goods are being supplied, and therefore the licensing is just not the primary part of the agreement. Does everyone agree that therefore the block exemption applies, or do others see it differently?
Let's maybe go to somebody we haven't heard yet. Daniel, would you be able to share your thoughts on that one?
Daniel is not hearing you.
Oh, I'm sorry, I didn't catch that. Well, can you hear me well?
Yeah.
Yes, sure.
Okay, perfect. I think about it, but I don't think that I have right now not even a draft of a solution.
Okay.
I'm sorry.
No, that's fine. That's fine. I mean, we're just quizzing people to get them involved. So also Annemie or Annabelle, I mean, please give us your views if you have any, or Eve. Let us know when you think that you may see a reason why it is not covered by the block exemption. Because Christian says it is covered by the block exemption, and the fact that we are asking, are you sure?
Well, not entirely sure. If I remember correctly, how you started today's class, I think you were talking about the transfer of the IP rights between supplier to purchaser, and not strictly the other way around.
Yeah, now we're on track. So the technical inputs and the IPRs are handed over by the Cuban producer Crystal to TAP. TAP is producing and supplying, and which means that the IPRs go from the buyer to the supplier and not from the supplier to the buyer, which was item number 1. Remember our slide? 4 conditions in relation to IPR. The number 1 is the direction of flow of the IPRs, only covered by the block exemption if it goes from the supplier to the buyer, and here it goes the other way around. TAP is the supplier, Crystal is the buyer. So we're outside the block exemption on account of the direction. But then, of course, we don't get desperate. That is not our nature, because I think, as Christian was indicating, we, in relation to paragraph 3, we discussed a subcontracting notice. What is your feeling in that respect? And you've seen the facts.
Yes. The Christian also made the point that there should not be a problem because it's outside.
Excuse me. Sorry, excuse me if I could interrupt. I'm from Hong Kong Competition Commission. My name is Trini, and it's my first time to join this module. But I'm not sure about whether in the description of the case, whether it has mentioned about whether Crystal will have any control of the cost, or I mean the cost of the production of the the Dutch company, because I understand that I can see it's quite nice. It seems it's an essential part for Crystal to ground the IPR to Dutch, but I'm not sure about whether in the case description it also mentioned about whether Crystal have any control or investment on the production.
And may I ask, Jenny, why you think that would make a difference? So why do you think is it relevant whether or not the Dutch producer TAP or its costs are being controlled or being somehow monitored or otherwise under control of Crystal?
Because usually I would also in practice we'll also maybe do the company check, or because I'm not sure about whether the company company has any relationship, and if I think if they has like control or investment on the company, or even like Crystal have direct involvement in the business operation of the Dutch company, I'm not sure about whether we'll think about a single economic issue.
Okay, but let's for the moment assume that TAP and Crystal are separate companies. The Crystal is not owning or controlling or having a shareholding in TAP. So they are really independent companies from a competition law perspective. So in that sense, it is really that the IP goes up from Crystal to TAP, and TAP is the producer and sells the goods to Crystal. Yeah. And the question now is, can they make use, like Christian indicated, of the subcontracting notice and say this falls outside the 111, so term P, it is not covered by the block exemption, it's not really my problem. It falls anyhow outside 111 because of the subcontracting notice. Do you all agree with Christian, or do you think maybe it's a bit too quick in its analysis? You have to. Do you think you have to complicate it as lawyers often do?
That last remark you simply forget. That is,
okay, Belgian lawyers often do.
Luc is an economist and he's Dutch, so that combination is. Shall I read a part of the assignments to you? We say here, TAP is willing to take the production of the appliance on board, but lacks the technical input that is needed. Subject to stringent confidentiality undertakings, Crystal is prepared to provide crucial technical know-how and all the necessary production drawings. This should enable TAP to engage in quality production of the Crystal products. That is what is in the workshop assignment description. Is that description helping you in any manner with regards to the application of the subcontracting notice?
Well, I think as we discussed, the question would be, would TAP be able to perform these services or act as an independent participant on the market without the technical know-how? So could it provide these services but for the know-how and technical input by Crystal? If yes, I think we're in the application of the subcontracting notice. If not, probably outside of the scope.
And I think with this description, I think, at least as a lawyer, maybe I'm naive, but I think as it is described here, I would feel rather comfortable that we are within the subcontracting notice, because the way it's described here suggests that TAP, our Dutch friends, would not be able to produce these household appliances at all without the input they receive from Crystal. So I would certainly thoroughly defend that we can make use of the subcontracting notice if this description indeed, of course, bears out in practice. I don't know if there's anything.
Yes, no, you can go to the solution slide. Yeah. So indeed, I mean, Christian, I think you were spot on. I mean, except that you thought that the block exemption might apply. There, I think it is clearly not the case. But for the rest, that's indeed what is at issue here. You have a situation which is vertical, but the block exemption does not apply, and not because we want to be stricter, but because there are reasons to be more lenient. It is the indispensable input of know-how that is supplied by Crystal to TAP, that allows TAP to produce, and which is also the reason why a exclusive supply obligation falls outside 1011 according to that subcontracting notice. And the logic is that if you cannot get the exclusivity, then it would be very unattractive for Crystal to provide the know-how and the licensing to TAP, because then TAP could become the producer for its rivals. And therefore, if you want to incentivize this kind of pro-competitive investments, you have to allow the exclusivity to take place.
Okay. Now let's try to.
I have a question. So can the exclusivity then be unlimited because it falls outside of the block exemption and even of the 101? Then
okay, on that one, I mean, Christian also made the right remark that firstly, the duration limitation under block exemption of 5 years only applies to non-compete. Non-compete is supplier saying to buyer, don't purchase competing products. Here it is the other way around. Here it is the buyer who says to the supplier, supply to me exclusively. There is nothing about the duration limit on that in the block exemption. So even if it was an exclusive supply obligation which was covered by the block exemption, let's say there was no IPR involved, etc., and TAP was producing for Crystal, although and Crystal was not a manufacturer at the same time, then the 5 year, there was no 5 year question whatsoever for the block exemption. So it doesn't play. Secondly, under the subcontracting notice where we're talking now, there's also no time limitation. The only limitation that you could think of is that it of course applies for as long as the provided IPRs are indispensable for the subcontractor to produce. The moment that, let's say that it was know-how that was being provided by the buyer, but that over time the know-how becomes general knowledge and cannot not any longer be claimed to be necessary therefore for the subcontractor to provide the products or to produce the products. At that moment, the subcontractor notice stops to apply. But in principle, there is no time limitation on the application of the subcontracting notice, and therefore also not on the conclusion that such an exclusive supply falls outside the 1011.
Okay. Any more questions? Otherwise, we're going for, again, interrupt me if you want to, if you have questions for a wrap up. You'll see that Luc and I are not really very ambitious people, in the sense that what we want you to take on from this session to be ready for the next session is the following. The basic question you always put is threefold. One, does Article 101 apply to my vertical agreements? My discussion we just had on subcontracting notice, it may well seem that it smells restrictive, but in fact, we can keep it outside 111. That's always the first step. Second step, if it does, can I make use of the block exemption? If that is not the case, can I in that case go for self-assessment 1013? That is the basic setup. Also, when I give advice, which I always follow, step 1, step 2, step 3. For the application of Article 111, what we want you to retain from today's session is you need 2 or more independent undertakings, which in a vertical area is important. For 2 particular categories is the intra-group arrangements between companies of the same group, which are organizing distribution, where you have one single undertaking if they're part of the same group. And you remember this agency construction. With agents, you have to always watch out because it may well be that they do not qualify as an independent undertaking. You need an agreement or concerted practice, but that is chewing gum. That is a very broad notion. And you will need an object restriction, no discussion about appreciability, or you need an appreciable effects restriction. And this appreciability standard is something you typically would be trying to fill in with the help of your de minimis notice. And then the final condition is you need an effect on trade between member states that is your entry condition to apply, EU competition law. Of course, if that is not satisfied, you go towards national competition law. Once you are in Article 101.1 and you want to go for the second step, your block exemption, what you retain from today's session is that you will first have to make sure that you fall within the scope of application. There you will need a vertical agreement which contains vertical restrictions. You will have to check your 30% market share limit, and you remember it's 2 times supplier buyer, but essentially on the same market, the selling market and the purchasing market. You will check your IP rights. Remember our discussion, the 4 points, to see that indeed we're meeting each of these 4 points. So even though there are IPRs in our agreement, we are safely within the scope of application. You will check the competitive relationship between the parties. And you will remember that only in dual distribution, where the parties are competing at a downstream level, competitive relationships do not block the application of the block exemption. And finally,
sorry, and the downstream level is the distribution level.
Distribution level, indeed.
Not, I mean, so downstream level at the intermediate level. So if that's the example of Volkswagen selling a engine to Peugeot, and they compete at the production level of producing cars, that is not covered by Article 2.4. It's only when the competition between the parties takes place downstream at the distribution level. And then for services only at the retail level, and for goods it can be wholesale or retail level.
Again, a small footnote, this may change in the future regulation. That is something which is being discussed. And then the final point is check whether there are any other block exemption regulations that may be applicable. And Luc mentioned the technology transfer block exemption regulation, TTBR. If any of those other block exemptions are applicable, you land with your agreement in the scope of application, you will apply that other block exemption and not our vertical block exemption. Then you make the application once you're in the scope of the block exemption. You make a distinction between the blacklisted or hardcore restrictions. If you have one of those, over and out, agreement is not covered. If you have an exclude restriction and you don't meet the condition of Article 5, that restriction may not be benefiting of the block exemption, but you can rely on the block exemption for all the rest of your agreement. If for some reason you're outside the block exemption, you don't get desperate. In that case, you know that the self-assessment based on the 4 cumulative conditions of Article 101.3 are your ultimate rescue plan. In the past, you could notify your agreements to the Commission. In some cases, you could notify agreements to national authorities to get legal certainty. At this point in time, important for you to know, self-assessment entails an element of uncertainty and risk, because only if you start enforcing the agreement or somebody lodges a complaint and an authority, a competition authority or a judge pronounces on your self-assessment individual application of the Article 101.3 criteria, you'll be sure that indeed you've done a good job. So as practitioners, we don't like self-assessments, to be honest, because they are inherently uncertain. But if need be, they are an important final step of your analysis if you cannot indeed save your agreement on account of the block exemption or because it lands outside Article 101.1.
And I would still add that on the slide, because Frank always immediately jumps to, then you have to do a self-assessment under Article 101.3. But I would argue there's also the possibility to argue that there is no 101.1 in the first place. It's not because you are above 30% or your non-compete is longer than 5 years or whatever, that therefore there is an effect on the market. And if you look at the development of competition policy, then since the 70s, 80s, 90s of the previous century, you've seen as more and more an effects-based analysis. That means that there is not this kind of presumption that a particular type of restriction has an effect. No, you can question the authority on its conclusions, why it has that effect and why they come to that conclusion. Because why are competitors not able to find other ways to distribute their products? And why is what you're doing hindering competition? And why would that be bad for consumers? And therefore, the first step is also find out and argue why there is or is not a Article 101.1 situation in the first place.
These are your 3 steps: 101.1, block exemption, self-assessment. May we kindly ask you for the next session, if you don't have much time, I assume you're busy people, simply flick through these last wrap-up slides before we start next time, so that you have the sort of framework in mind once we do our deep dive into some of the more detailed aspects of the block exemption regulation. That would be highly appreciated.
And read the regulation. I would also add read the guidelines, but at least read the regulation. It's a short document.
It's written by Luc, it's almost poetry.
Yeah, I wouldn't say it's poetry. No, not at all. But at least I hope it's clear enough.
Final question from our side. Anything for present purposes, this first session that remains unclear, anything we can help you with? Any open points? Anything we have been unclear about? Or can we quietly and comfortably go into the weekend? Don't tell me next time that you have not been able to sleep through the entire weekend because it was something which was bothering you. The time to resolve that problem is now. I don't see any questions.
Okay.
Then we can wrap up.
Yes. Indeed, let's wrap up and then meet again next week on Friday at 1:30. I really hope we will make it to the classroom and do the live. For now, it's still the case. So in any way, if we have to cancel, you will receive an email from me about this. But thank you very much already, Frank and Luc, for this afternoon. And if there is any question, keep it until Friday. Thank you. Goodbye.
Thank you very much.
Bye
Great
bye.
lecture.
Thank you very much. Have a nice weekend. Goodbye.